Any mention?
May I please, Your Lordship? I beg to mention item number 60.
Contempt.
No, my Lord. Is it
16.
60?
60.
Yes.
My Lord, I pray for 2 weeks' time, my Lord, for this case.
Why?
Because the conducting counsel is out of station, my Lord.
When's he coming back?
Maybe.
Today?
No, my Lord. Maybe next week.
1 week, yes.
Much pleasure.
Please, Your Lordship, item number 61. I was directed to produce the record, my Lord. So today morning only I received the record. I want to go through the record, my Lord. So I have taken a concern. Mr. A.J. Momin is there, my Lord. So let it come after 2 weeks.
He submits the records. I've just received this morning. He prays aloud. He prays the matter be adjourned for 2 weeks. Allow him to examine the same. I pray aloud for 2 weeks. Yes.
Hello.
May I please, Your Lordship? I'd like to beg to mention item number 63, Your Lordship.
On whose behalf are you mentioning?
I'm on behalf of K.V. Carlington, Your Lordship. And the petitioner, K.V. Carlington.
On behalf of?
The petitioner.
Yes, you have
Lordship
objection.
for respondents 1 to 4, Your Lordship.
No objection.
No objection, Your Lordship.
Prayer for 2 weeks' time, Your Honor.
2 weeks, okay. Yes.
I'll reply.
Please, Your Lordship, I beg to mention item 59. The conducting counsel is out of station.
Who's your leading counsel?
P3.
Why are you avoiding this case? 59. Where's
Yes.
Dr. Mozika? You have the brief with you?
Pardon, Your
You have the brief with you? Is a file
No,
with
Your
you?
Lordship.
That matter regarding reduction of sentence. He's avoiding this case.
No, Your Lordship, she's out of station.
Okay, after?
2 weeks. 2 weeks.
Yes. 1 week, 2 weeks.
2 weeks.
Okay, 2 weeks, yes. Okay, yes.
Obliged.
I beg to mention, my Lord, allow me to move one motion tomorrow. Transfer matter. We are filing, my Lord. He's a teacher, my Lord. He's a teacher. He has been transferred to Karo Hills. My
So
Lord.
why is he a government teacher?
He's a government teacher.
Then why is he agree with the transfer?
My Lord, he was suspended for 4 or 5 years. And he came before this court, and this one court passed an order for reinstatement. Recently, he was reinstated, and criminal case, POCSO case also discharged from that proceeding also. And certainly now, in the school where he was there, the contractual appointees is there. Now petitioner is transferred to Karo Hills. He'll be serving less than 1.5 years, my Lord.
He's got 1.5 years.
1.5 years only, my Lord.
See, maybe because he was involved in whatever allegation,
My Lord,
they don't want him in the school anymore.
My Lord, that case also, my Lord, no longer, my Lord.
Whatever it is,
Case
but
has
then
been
the
closed.
Public,
Case has been
perception is different.
Case
Okay,
has been
tomorrow.
deeply obliged.
Your Lordship, I beg to mention item number 64.
Where's the petitioner?
I'm the petitioner, Lordship. No
Your
objection.
objection?
No objection, Lordship.
What's the matter about?
Family
pension.
Family
pension.
pension?
Yes, Lordship.
Then 1 week is. You're for whom?
For the petitioner number, respondent number 4.
Second wife?
Second,
No, first
first
wife.
wife, first wife.
Okay. 1 week.
Thank you.
Supplementary list item number 1.
What is this contempt?
Good morning, Your Honor.
What is this?
Your Honor, it is regarding a contempt case I have petition
Yes, what is
for
which order?
writ petition. Writ
You
petition
are appearing personally?
Yes, sir.
You are Mr. Lewis Suting?
Yes, sir.
Okay. Yes. Why contempt?
Sir, because as per your order, it was not carried out. It was not complied
You
with.
have not till now not complied.
No, it was complied on the 4th day, but on the first 2 days, she refused to open the gate. She made excuses that my son has got the key. The police called me 3 times after I was staying in the hotel. I vacated the
Why
hotel.
have you made the lawyer as the respondent?
Yes, sir, because the lawyer was the one who said that he had complied with the court. After hearing it on YouTube, he said he's complied with the order. He even told the executive magistrate that he complied with the order. But the executive magistrate has stated, no, we've got a police report saying.
He's here.
The magistrate is in the file here.
See, the thing is that if you have any complaint against a lawyer, actually the right forum is a bar council. So even if it's misleading or for misrepresentation, the decision for the court is different whether the court takes cognizance of it or not, under what circumstances.
But I'm only petitioning through Article 215, sir.
We understand. We understand your file. You have your grievances. Anyway, we're not assisted by any counsel. Who was in counsel earlier on?
Counsel was Tracy Strugner.
Why not taking the help?
So because although I'm not impeded her, she didn't object to when he said that he had complied with, sir.
No. I mean, why you've come personally?
Because I can't afford the fees again, sir. I've already paid a lot for this fees for getting my. I paid a huge amount.
One thing, you will issue notice. Okay, heard Mr. Suting, who's appeared in person in instant contempt application. Stop next paragraph. It is submitted by Mr. Suting that the respondent number 1 had misrepresented before this court with regard to the compliance of the order dated 6/2,
sir.
6/2/2025, passed in WPC number 7 of 2025. Stop. Though an appropriate course of action against respondent number 1 would be to make a formal complaint before the bar association or the bar council, let notice issue to respondent 1 together with other respondents within 3 days by registered AD, returnable in 2 weeks. List on so and so.
Thank you, sir.
Actually, the course is anyway. But now comply. You've entered the premises, correct?
Yes, sir.
Item number 2.
May it please your Lordship. This is an application under section 29, subsection 4 of the Arbitration Act for extension of time.
Who's appearing on the side? Dr. Mozilla?
I think we'll have to take.
Mr. Chakravarti Council issue notice, returnable in 2 weeks. Steps will be taken by the AD within 2 days.
All right.
This court appointed the arbitrator. From the High Court, arbiters are appointed. You've seen my judgment on 29/4. There's a judgment regarding which court there's a judgment which has been passed by this court also.
Okay.
It's gained a lot of traction all over the country with regard to extension of time.
Okay.
Yeah.
We'll go through it. All right.
Daily list item number 1.
Yes. What has happened in these matters, Mr. Dingo?
Still, we have supplied all the documents, whatever they want.
As per the report of the special officer who has been appointed,
Yeah.
notices were issued to all the traders, but only the petitioner number 1 has responded.
How is that possible?
No, my lord, we have submitted. If required, my lord, we can furnish a copy of all the documents. We will compile it, my lord. We will submit it before this honourable court, my lord.
My lord will see the order dated 21/11/2004 passed by this court
In a contempt?
in the contempt.
20?
21/11/24. An affidavit has been filed on behalf of the sole respondent.
21/11.
Yes.
Yes, sole respondent.
An affidavit has been filed on behalf of the sole respondent wherein it is indicated that the petitioners have never routed the applications to the respondent. However, in the same affidavit, it is stated the chief executive member has since approved the renewal of the trading license of the petitioner and others subject to verification of all necessary documents. In this view of the matter, it appears that certain compliance has been made with the orders of this court. However, Mr. N. Raji, learned counsel appearing for petitioner, submits that due. So, my lord, what has happened in this case is that as per the order of this court, the petitioners were supposed to file their applications to the secretary, which was not done. They went directly to the licensing officer.
Okay.
That was the order in the writ petition, my lord. That was the order in the writ petition.
So it was never routed through the secretary. Now, as soon as the notice of contempt was received by the secretary, he immediately appointed a special officer, and the special officer has issued notice to all the.
No, but if the applications are already submitted for this, why can he take those applications and consider?
No, my lord, because there's a here, my lord, your lordship will see page 40 of the contempt petition, which is the order of this court.
Yes.
But as the process was taking an unreasonably long time, contempt applications alleging non-compliance of the order dated 16/12/2021 were also filed by the writ petitioners. In the course of hearing, however, on a detailed examination of the Regulation 1954, it was noticed by this court that Section 3A, which contains the conditions for granting or refusing a license with regard to a recommendation, or in this case NOC, it has been provided at Section 3AC that the application was to be recommended by the village headman after being duly approved by the local darbar. The entire exercise, therefore, which had been gone into by the writ petitioners before the respondent number 1, the CM of Sora, for grant of NOC was therefore an exercise in futility, inasmuch as the CM of Sora, being the chief, had no role to play as per the regulation. At the time of hearing, so-and-so learned counsel for the respondent number 1 on this aspect had also fairly submitted and conceded that perhaps the grant of NOC from respondent number 1 would not have any role to play, as under recommendation of the village headman, the application for grant of trading license was to be dealt with by the issuing authority, that is respondent number 2, the KHADC. Now, my lord, while going through the records of all these petitioners, it would appear that the NOC, their first NOC, which they had obtained, was from the CM of Sora and not from the village headman. Now, as
So you see that you need to take corrective measures now.
Yes.
They have to get an NOC afresh from the village headman.
Because that, it implies that, because in the earlier round of litigation, it came to light that they were seeking NOC from the CM. Whereas the CM is not the authority, is not the competent authority. That's why we have said that you please provide us all these documents, necessary documents, and we'll go ahead. Because the lordship will see the.
My lord, if my lord can kindly see the letter which has been issued to the senior counsel, my lord, by the district counsel special officer, my lord. They are playing hide and seek, my lord. Now, if my lord peruse this, the third line, my lord, only so and so submitted the petition for renewal along with the documents, professional tax, this, and old NOC from CM, SORA, and income tax. Here they are not mentioning anything about the headman. Now, and they are accepting that old NOC of the CM of Sora, my lord. But verbally they are telling us go and get a headman certificate, my lord. And headman is not issuing us. That is the core issue, my lord, which was in the writ petition. Whereas here it is not a fresh license, my lord. It is only for the renewal.
But even for renewal, my lord, your lordship had held, even the last order has said that as per, your lordship would further read the the order which was read just now. My lord, page 41. Having heard the learned counsels for all the parties and having given due consideration to the facts and circumstances of these cases, this court appreciates the stand taken by all the counsels for the parties to resolve the present imbroglio. As such, without lingering with the matter any longer, it is hereby directed as follows. All the writ petitioners in these writ petitions shall apply individually for renewal of their respective trading licenses by submitting their applications before the so-and-so. On receipt of their application, the respondent number 2 shall dispose of the same within a period of 8 weeks thereafter. It is also provided that respondent number 2 in this exercise shall nominate and authorize a special officer to process the said application and to put up the same before the licensing authority for further necessary action. It is further directed that in an examination of the applications, the same shall be conducted in a fair and transparent manner, and the writ petitioners be afforded adequate opportunity by the respondent number 2 to clarify any issue that may arise.
So
That
anything,
that the process.
if the issues have arisen, you should have given them like specific notice on this part only.
Yes.
With regard to the NOC that you have
Yes.
furnished is not by playing, by saying that no, you have not submitted in that. Because the court order says clearly that on examination applications shall be conducted in a fair and transparent manner, and a writ petition be afforded at a point. Now, if the applications had been given, as they say, that they've submitted all these applications, they stated all these petitioners rather, they've submitted the applications. Now, what prevents, you can take them up for consideration one by one, licensing officer, he'll have enough time, give enough time, and if there are any issues individually, then he will inform, not to say that I issue notice again to all the people in Majai. You see, you can't just, turn back, whole process all over again.
But the difficulty here, my lord, is that all the NOCs were issued by the same officer, rightly or wrongly.
Whatever,
Yes.
then that they should be informed about that NOCs, that you have to obtain fresh NOCs from the bridge headman or from whatever authority, Sardar or whatever. It comes under Sardar Majai.
Yes, yes, my lord.
Because, my lord, number 443
Sardar
was,
Majai is at odds with the scheme of Sora.
it appears so.
And
Because
more
this is a case where the same of Sara had tried to assert himself initially. Then when this court pointed out that it's not the same, in fact it's the village headman who should issue an NOC, then he...
But similarly in East Khasi was one case that since if there's no headman, then let them go to the scheme, like in that...
Yodo area.
area.
Yes. That is a different issue.
Now, my lord, from time immemorial, my lord, they have issued with this NOC only, they have issued me the trading license. Now, suddenly, my lord, because of some issue, my lord, they cannot close the door, my lord, by saying that now you go and get a fresh NOC, my lord.
No, but if
The process of... My lord, will come to page 249. Rule 3
of the compendium.
Of the compendium.
1 second. I have to wait. Yes.
Page 249, my lord, subparagraph 2. In case of a license granted, the same shall normally be renewed on an application unless there is any complaint or any other consideration which the executive committee thinks fit to call for a report or fresh recommendation from the village headman and his durbar.
So, if in case there is a complaint, my lord, the proviso is there, my lord. If in case there is a complaint, so whether there is a complaint, my lord, against this petitioners.
No, but the question.
One thing, Mr. Lindo. See,
Yes.
you have to streamline the whole thing because
Yes.
it's not the case happened because of certain thing that this license was renewed. The thing is that court has passed orders that you license the special officer be appointed.
Yes.
Is to examine the thing, and if you have to go as per the act, that's all.
Yes.
Simple as that. So if there's any shortfall on the part of the applicant, that has to be intimated them individually, not by general notice. General notice.
No, it has gone individually, my lord.
We have not received, my lord. That is,
You
there is
take
no instruction. I will
Yes.
take instruction
That
on this.
is
my lord.
instruction.
Yes, today Mr. T. Lindo has furnished has has shown to the court a communication dated 28/2/2025 indicating that notices had been issued to the traders at Majai East Khasi Hills on 25/11/2024 and 3/12/2024 to submit their individual petitions, but that the same has not been applied except for one, Sri Chansal Devnath. Stop. Next part. It's important. The letter has been perused. However, it is important to note that the directions of this court in the order dated 4/10/2023 have been specific, and apart from directing that the renewal should be considered in accordance with the Act and rules, certain directions have also been issued whereby a special officer has been directed to be appointed to process the said applications and to put up the same before licensing authority. Stop. Next paragraph. Like, as there seems to be some confusion with regard to the status of the applications and manner of presentation, the council please be allowed to.
I'll take the instruction and let them also give.
Yes. Further provided that the respondents also shall take proactive steps in this matter, so that the issue can be resolved at the earliest. Yes. This is the matter of 3 weeks.
Right. Order will carry till item number 43, my lord. Seymour.
44.
Your Lordship, in this matter, the respondents are supposed to file their affidavit. We have just received a copy of the affidavit filed by the respondent number 7, Your Lordship. The other respondents are supposed to file.
Your Lordship, in this case, Your Lordship, I have been informed that the ex post facto approval of the government to regularize the service of late Nefso, their grievance has been addressed in a way, Your Lordship.
Are you aware of that?
Lordship, we have just got the clear instructions. They have not processed yet, Your Lordship.
It has been processed. This is a letter dated 17th February.
Has that been processed?
Lordship, it has not been processed. We've just received the instructions.
See.
Let them bring on record,
issue
Your Lordship.
is to be, now the order has to be issued, Your Lordship. Otherwise, the regularization has been allowed.
Communication dated 17 February
Lordship,
2025 has been produced for this court, indicating the fact that compliance of the orders in process.
That was one of their prayers in the writ petition.
Yes. Where's the order?
The order is on page 10, Your Lordship. Page 10 of the contempt.
This is pension or this is for
This is for
realization?
pension, for the release of pension and terminal benefits, both, Your Lordship.
Oh, you not regularized.
He was not regularized.
Staff taken over by the
District
by the,
Council, Your
over by
Lordship.
the District Council, Your Lordship.
Yes. No. Not compliance, adding the fact that the ex post facto approval to regularize the service of late Neferin K. Sangma has since been approved. Have since been approved. Stop. Next paragraph. MS T. Yangil BEAG submits that as the process of realization is it will be completed, other benefits to which the writ petitioner will be entitled to will be consequential in the due process. Stop. Accordingly,
Lordship, time frame may be given, Your Lordship.
No time frame because it's contempt won't give because see it's twofold. Now you come for contempt against the pension. The fact remains that is that you never regularize also. Now regularizing your services first, then it'll follow. So it's expected that the regularization and release term will be done at the earliest. Yes. Next part for contempt is at this stage closed. Yes, you can come again.
Pledge, Your Lordship.
Item 45.
We've received the rejoinder filed by the petitioner, Your Lordship.
The rejoinder is against our affidavit.
Their
In
affidavit,
fact, the
Your
state
Lordship.
government has not
We have
any
not
affidavit.
filed affidavit.
Right.
Those were instructions, Your Lordship, because we don't have much role to play except for giving permission to the yatris for conducting the procession in a peaceful manner.
In fact, that, my lord, is a big role by the state government. They should also, I don't know why they're shirking the responsibility of filing an affidavit.
What's this statistical account of Hunter? What is here?
My lord, it's an old account that we've managed to locate. It's from 1884. If I can draw Lordship's attention to page 12 of the affidavit that we have filed. Quickly read the second paragraph, my lord. Natural phenomena. Many peculiar caves and caverns are found in the limestone rock formation, the most notable being the caves at Cherrapunji and at Roopnath in Aumi. At the latter place, the caverns extend a great distance beneath the earth, one being imagined by the people to reach as far as China, and a Hindu legend states that a Chinese army once marched by this route to the invasion of India. In another cave, the limestone stalactites have been carved into images representing the gods of the Hindu pantheon. On the banks of it goes on, my lord. So in 1879 itself.
Where does it talk about this particular cave?
This is the reference, my lord. In another cave, the limestone stalactites have been carved into images representing the gods of the Hindu pantheon. This is the cave in question, my lord.
I don't think so.
No,
because the other case where the carving is this is.
My lord, we'll see the first line of that paragraph itself. Many peculiar caves and caverns are found in the limestone rock formation, the most notable being the caves at Cherrapunji, and so and so. With reference to the
particular about this Mosanram.
The word Mosanram is not mentioned, but Cherrapunji is mentioned, my lord. And in that area, to my knowledge, there is only one cave with this sort of a peculiar formation, my lord. So, in point being, my lord, that in 1870,
not been carved because the other places were carved, which have been due to road construction and all. That is to my personal knowledge. Anyway, like rejoinder to the affidavit filed by the response number
6, 7, and 8.
6, 7.
This is the village.
Yes.
Has been filed. This the matter when?
There is some urgency because the yatra is for this year is coming up again. 2 weeks, my lord.
2 weeks. 2 weeks. Yeah.
Item 46.
My lord, we have filed the affidavit today morning and we have served a copy to the petitioner.
We have just received. I'm praying for 3 weeks' time to file the rejoinder affidavit, Your Lordship.
What's the matter about?
The Nokma shipment.
Affidavit on behalf of the respondents number
1 to 4, my lord.
1 to 4 has just been filed. 5 and 6 already filed.
Lordship, we have received.
You filed rejoinder?
Lordship, we will. Lordship.
All of the affidavits.
Lordship, we will file it together.
Yes, next paragraph. So has just been filed. Stop. Ms. Humso prays that she be allowed for the petitioner please be allowed to file rejoinder to affidavit filed by the respondents 1 to 4 represented by Mr. SD and 5 and 6 represented by Mr. Pasanthi. Just after
3 weeks, Your Lordship.
3 weeks. Okay, 3 weeks.
Item 47.
Your Lordship, we have received the affidavit in opposition. We are bringing some time to file our
Who has
rejoinder,
which,
Lordship.
from whom?
From the managing committee, Lordship.
Managing committee is 3 to 5.
1 and 2, Lordship.
1 and 2, do you file it since when have you filed it?
February, Lordship. 13
Then
February.
you just received it just now.
No, sir, we received prayers.
What about 3 to 5? Yes, MS.
3 weeks time, Your Lordship.
Lordship, there's an interim order in their favor, Lordship.
Yes, please, what's the matter about?
Lordship,
removed from the
she's an assistant teacher of a school, Lordship, and she's given additional charge of a head teacher. Now there was certain complaints against her, and she was removed as a head teacher, Lordship. There was a
senior most.
Lordship, there was a detailed inquiry held against her. Now she has only come challenging the order, Lordship, but not the inquiry report.
File your rejoinder
Yes, Your Lordship.
within 2 weeks. Yes.
3 weeks time because she is on maternity leave.
She's?
The petitioner is on maternity leave, sir, Your Lordship. She is having some difficulty.
Can't show gender bias. That's 3 weeks allowed for rejoinder.
Interim order may be extended.
Interim order if any shall continue the next day.
Obliged.
She's on leave, then she can't discharge her duties.
48.
For 2 weeks time, file affidavits.
How many times have you played? Have you received instructions?
Lordship, yes, we have
Let us
received
see.
this.
What's the matter about?
It's with regard to regularization of the services.
Lordship, the file.
We can't have. With whom?
With Mr. Bhattacharya. I'll just get it in my notes.
Who's appealing this matter?
Mr. Bhattacharya.
You're appealing.
He's the conducting note.
Then where is he?
He is. Lordship, he's in a different courtroom.
Yes, what is wrong? Come. Yes.
My lord, there are 2 affidavits, my lord. So I'm praying for some time. So lengthy ones, my lord. Lot of annexes.
What lengthy ones? This is filed since October last year.
Yes, my lord.
Then why 2 affidavits?
My lord, because the respondent, the last respondent, my lord.
Why the 2? You're filing 2 on behalf of 2 entities.
One will be on behalf.
All social welfare. And
One will be on behalf of social welfare, my lord.
Who's appealing for 5?
My lord, Meghalaya State Commission.
Who's appearing?
I'm appearing on their behalf, my lord.
Then why are you appearing for government and for state commission? What's your instructions?
The contentions,
What will you-
my lord, the contentions are that they are not entitled, my lord. There's
Then
no
file
such
it.
scheme only.
If upon a scheme you file it,
Yes, my lord.
how many? You can't take time repeatedly. You know this. Since 6/11, further 2 weeks time, further 2 weeks time for affidavit. This final opportunity of 2 weeks
Yes.
allowed for response to file affidavit.
Item 49.
Yes. I'll put that.
Lordship, I'm praying for some time, Lordship. Just a week's time, Lordship. We have to send for signatures to the commission.
For this for MPSC.
State Information Commission, Your Lordship.
Yes, as paid for the 1 week's time allowed to the respondent. One to file affidavit. Interim order shall continue. A little further order.
Highly obliged.
50.
My lord, here I'm praying for 2 weeks.
You're 8 or 6 and 7?
I'm 6 and 7, my lord.
And SD Sangma?
Is for
With
8.
you. Why? And state not filing affidavit.
My lord, state also. We are,
Already filed.
no, my lord. We are praying for 2 weeks.
6 and 7, my lord, we have filed our affidavit, my lord.
6, 7, 7, Lordship. They have filed.
Mr. SD, as step opinion for one number 8 praise phones allowed for a constant affidavit. Some opinion accused but Mr. Kibatagi for 1 to 5. Yes, praise allowed just after 2 weeks.
51.
State is yet to file their reply, my lord, on this matter.
Please, Your Lordship. Your Lordship, I'm praying for 2 weeks' time to file an affidavit.
Mr. Khan,
Yes, Your Lordship.
you have to give time. Teachers got married yesterday, correct?
Yes, Your Lordship.
Further 2 weeks time allowed to come to the government response file.
Obliged, Your Lordship.
52.
Any further hearing necessary?
But I've prepared my bullet points, my lord, just to assist your lordships
Bullet
properly.
point looks like a whole volume.
No, my lord, it's just 3 pages and then judgments, my lord. I've flag marked the judgments also, my lord.
But quick.
With bullet points. My lord.
Earthquake just now, no?
I can't hear it.
Yes.
So, my lord,
What about now we'll hear only 25. This matters heard.
Yes,
Your
my lord.
matters, I mean, you already made submissions.
Yes, my lord. So,
Mr. Shillar doesn't look satisfied. Why only made some more submissions? No, but then there was
Milord,
there
Milord, we are on illegality, my lord. 2 points, my lord. One is Invest Meghalaya, which was an essential condition, my lord. Now that has been brushed aside and not discussed. Despite your lordships in the previous round, my lord, discussing the entire issue, my lord. They have just brushed it aside. Number 2, my lord, 75-25 has not been decided by the...
That is not your
by
case.
I'm on it. My lord, has not been decided by the tender committee. There is no relaxation clause, my lord, in the NIQ, my lord, in the terms and conditions. And my lord, cartelization, my lord. The market price, my lord, of per bundle, my lord, including transportation, is 9,000, my lord. The price quoted is 17,500, my lord.
The price market 9,000?
Yes, my lord. Double, my lord.
Is that
And
correct,
two people get the same price, my lord.
I don't know on what this is done.
What ask that time? What is the thickness of that?
It's already mentioned in the
tender itself. What is the thickness?
0.45.
45.
1.5 is 9,000 a bundle.
Yes, my lord, including transportation, including GST. My lord, exactly, I do not know how many sheets, but one bundle is 9,000, my lord, max, my lord, with transportation, my lord. And I am a manufacturer, my lord, I know it, my lord. They are only doing corrugation, my lord. They buy the coil and just, my lord, cut them into sheets and supply it, my lord, and put their mark, trademark.
I'm not going to go there. Anyway, item number, that's been WPC 478 and Mr. Shila, your WPC's number?
52. Oh, WPC number 478.
No, that 4 is yours.
Yes.
Then Mr. Shila's WPC 47 and 24 480 CAVS. You want to make any bullet points?
Just place some judgment.
You're not going to make any bullet points? Fine then.
Judgment by this honorable court regarding.
What about you are for the
For a state, your lordship, in fact, your lordship, I'm citing the judgment passed by your lordship in one of the case. Give me the file.
I've just cited one judgment of this honorable court regarding cartelization.
all are giving my own judgments only. Very make it difficult.
SM
same pricing, my lord.
Energico Limited, your lordship. Though this is a cancellation, your lordship. Lordship has in paragraph Lordship, in this judgment has quoted that Jagdish Mandal's state of Orissa case para 18, Your Lordship. Lordship, kindly come to para 18, Your Lordship, where Lordship was pleased to refer to that Jagdish Mandal case, Your Lordship, at para 22, Your Lordship. Lordship, I'll just read 4 lines from the bottom of that para 22. The tenderer or contractor with a grievance can always seek damages in a civil court. Your Lordship, if any grievances, Your Lordship, in my humble and respectful submission, then.
Where are you reading from?
Lordship, Lordship, kindly come to para 18 at page 26, Your Lordship. Lordship, the fourth sentence from the bottom, Your Lordship.
Yes.
The tenderer, Your Lordship. The process is fair, transparent, Your Lordship. They took part in the selection process only when they were not successful, Your Lordship. Then they make out it.
This is from Mr. Shilla. That was that.
Paragraph 12, my lord. Which talks about same pricing, my lord. My lord has held there are identical rates by 4 tenderers is against the basic principle of competitive bidding and is contrary to the purpose and concept of an open tender system. Such tender practice needs to be discouraged, and in the event as has occurred in the present case, especially in item-wise contract, detailed cost analysis should have been gone into by tender to arrive at the most suitable bidder as all the rates quoted were identical. In this case also, my lord, not only identical, it's same, my lord. Although this judgment has been appealed, but there's no stay, my lord. The appeal is still pending.
What is this other judgment?
This is the appeal, my lord. Appeal.
No. Oh, okay.
Yes. Appeal, my lord, still pending, my lord. There's no stay, my lord.
Oh, it's the same judgment. Sorry, yes. I thought some contempt matter.
No. And my lord, in my writ petition, my lord, the respondent number 4.
You can't get this tin from GEMS, Government e-portal, Government e-market.
That is for central government entities, if I know correctly. High Court is purchasing from GEM portal.
Yes, state government is not bound.
Yes, that is binding on only central government entities.
The other case that came yesterday, what is that? You appeared, correct? Yes.
FCA.
Oh, you appeared, yes. Oh, you didn't appear. Who? Oh, Mr. Said, sorry. Yes.
That is only to central government.
That's FCI, yes.
And just last point, my lord. In my writ petition, the one of the respondent, my lord, Meghalaya Roofing, have filed the affidavit. And in their affidavit, my lord has the affidavit.
Yeah, what did he say?
In the affidavit, I'll just take to the relevant part, my lord. Page 5.
I'll just listen. Yes.
Page 5 of affidavit, my lord. It says here, my lord, that moreover, it's pertinent to place on record that though the Micro and Small Enterprise 2020 not applicable in view of the subsequent corrigendum, it is an undisputed fact that answering deponent had even submitted the requisite document clearly demonstrating that the deponent has submitted MSME certificate along with the application under Meghalaya investment at the time of submission of tender document along with the tender papers. So this is an admission, my lord, that they have submitted just an application of Meghalaya investment and not the certificate.
Who? Meghalaya Roofing is whom?
Meghalaya Roofing is one of the successful bidder who was given 25%, my lord. And as per the NIQ, my lord, it is as per the NIQ, my lord, one of the mandatory condition, my lord, is that all the bidders must have a certificate.
MSME.
No registration under the Invest Meghalaya, my lord.
All of you have.
No, my lord. Nobody has it.
You don't have.
No, my lord.
You don't have.
No, my lord. All of them are having this application, my lord. Because till then, my lord, we have inquired. No one has
Will
got.
that amount to totally disabling the entire tender process?
Exactly, my lord. That's why
no, because the thing is that, see, now you see, one thing is that even if you read judgment which you have placed, which is my own. The thing is that equity, national justice also, you can't apply so strictly in commercial matters. You see, because that it is a commercial matter. Now, balance of equities will not come. And even national justice to a certain extent. Now, the thing is that, especially with regard to tender conditions, if the substantial compliance is there in assessing the tenders by the tendering authority, that you have fulfilled the tender conditions, that is enough. And because we cannot, but the thing is that with regard to the 75-25, now, as per the corrigendum, the tender committee is to recommend that.
Lordship,
Correct?
I'll please my case, Your Lordship. So
My
for
lord,
that,
my
Your
lord,
Lordship.
if I may just add up to my submission, my lord. So far as this case is concerned, my lord, if you look at the background of this case, because there's already first round of litigation where my learned friend has come for his client Manaksha, and in that, my lord, the state has been have been putting its point regarding justifying Invest Meghalaya, that there has to be Invest Meghalaya, because at that point of time,
But he said he has Invest Meghalaya, no?
but so far as one of the successful bidder, my lord, one of the successful bidder, they have filed affidavit in my case, my lord, admitting that they just have application.
I do not understand.
No, my lord, it's not supporting one another, my lord, but this.
They are stretching too far, Your Lordship.
Matters
No,
may be segregated.
this is on record.
I'm filing this judgment in your two cases will come separately. 725 be separate.
Madam,
Because
727
we both
far,
successful tenderers, and in this case, the both failed tenderers.
They fail to fulfill the essential condition of the tender, Your Lordship.
Kindly have the judgment reported in 2006, volume 11. In the compilation, the blue flag, third blue flag.
Yes, and Joshi.
Yes, my lord. My lordships kindly have para 66. That is the white flag, my lord.
Yes.
Lord, this talks about essential conditions, my lord. That it cannot be relaxed unless and until it's provided in the terms and conditions, my lord.
But have you seen the latest judgment? I think past Chief Justice just retired. What's that judgment that is in
6. Now, my lord, kindly have the 2024 judgment, my lord. The last flag, my lord.
Yes.
This is a 2024 judgment, my lord. This judgment pertains to, my lord, disqualification on technical bid, my lord, and where the successful bidder, my lord, himself did not have a particular, my lord, condition, my lord. Your lordships will kindly have.
You've given them citation of this case?
Yes, my lord.
Given them?
No, my lord. I'll give them. I'll give them the judgment also, my lord.
What factor is no? Giving after operation will be
No, but even then.
My lord,
Para 18 onwards, my lord.
My lord, the case is very simple, my lord. They have come against their rejection at the technical stage, my lord. So, my lord, in
This
my
judgment
submission,
covers,
lordship
my
will
lord.
examine
My lord,
whether
kindly have.
their technical rejection was correct or not, my lord.
My lord, kindly have para 37, my lord. The last page, my lord. Para 37, last page, my lord. The submission made by the learned counsel for the respondents that the project in question being infrastructure project and also one that the mega project, this court may not interfere more particularly in view of the fact that the agreement has already been entered into between the respondent BCCL and the special service vehicle of respondent number 8 cannot be accepted when we have found that the impugned decision of the respondent BCCL was grossly arbitrary, illegal, discriminatory and violative of Article 14 of the Constitution of India, my lord. As held earlier, the government bodies' instrumentalities are expected to act in absolutely fair, reasonable and transparent manner, particularly in award of contracts of mega projects. Any element of arbitrariness or discrimination may lead to hampering the entire project, which could not be in the public interest. Now, para 18, my lord, if your lordships has. para 20.
One second.
Yes, my lord.
See, the thing is that you have to show to the court if you want, like if you seek interference, is that the decision, whatever was done, was malified or not bona fide and against public interest.
Yes, my lord, that is what I'm
Only,
showing.
that's the only thing. Otherwise, equity and national justice become a
My lord,
distance.
I'm totally on the point of illegality, my lord. There's an essential condition. My lord, the same judgment, if your lordships kindly have para 20. The same judgment I was reading just now, my lord. Internal page 285, para 20. When there's an essential condition,
Where did you from? Large, this para 20, the
bottom of the
after
page.
table.
Yes, my lord, bottom of the page.
Yes.
It reads, my lord, from the bare perusal of the aforestated clause 10, it clearly transpires that the bidders were required to furnish the information and the scanned copies of the documents relating to qualification criteria, particularly to substantiate their financial capacity. For the purpose of substantiating financial capacity, the bidders were obliged to submit the scanned copies, self-certified and notarized certified of the audit annual reports for the last 3 financial years, as chosen by the bidder, comprising of the audited balance sheets and profit and loss accounts of the bidder, along with other documents as stated therein. This was the mandatory requirement of NIT, the same being related to qualification criteria as also transpiring from clause so-and-so. Admittedly, respondent number 8 had not submitted the scanned copies of its audited annual reports for the last 3 financial
No,
years.
one thing, see, Mr.
Yes, bro.
Bromley, is that whether you have complied with all of it, that's all. And from what I remember, you didn't give your what's that called deposit. So you fail. So even like if you impugn the selection process, now you yourself also are you file a defective technical bid. Correct?
My lord, my fixed deposit is a call deposit if it can be prematurely withdrawn, my lord.
That we can accept that. Whether if you go by the same submission that you make, that the exact and precise and explicit criteria given, you should have complied with them explicitly. That's all.
My lord.
And also, like if it's sauce for the goose, sauce for the gander.
Now, my lord, on point of illegality, I'll again show one thing, your lordship, one part of the judgment.
So that's the thing. See, illegality. See, Mr. Philemon. See, the thing is that like this.
Lord,
now,
even otherwise,
now, if you're advocating a case that if your case was such that you were perfect in all respects and their tender bid was technically deficient, yes, then maybe we will say that in awarding the contract to the whoever is is not an exercise, it's not a bona fide exercise, and it's against public interest. But if a tenderer who himself also lacks in the criteria assails the action of tender committee, now where does that leave the court?
Well, this court has to take cognizance of these.
I mean, you cancel the entire thing and ask for fresh tender, allowing you to correct the defects and them to correct the defects. Then we remember to square one.
Yes, my lord.
See, that is not a solution.
It's a deficiency, my lord.
It's a deficiency,
because they are also technically not qualified, my lord. What I'm trying to say is they are also not technically qualified, and this court cannot turn.
You want this court to set aside entire tender process?
Yes, my lord.
You're disqualified. They're disqualified.
Yes, my lord. Everybody.
You can't sit
Fresh
on
tender, my lord.
over tender committee.
My lord, tender committee has not decided, my lord.
If you're perfect all respects, yes, the court would have really considered your case. But you also, we've seen that.
My lord, as per B.N. Joshi, my lord, this court has to take note if there's illegality, my lord. Irrespective
there's
of
another conflicting decision by Justice Chandrachud also in that Tata Motors versus Brihan Mumbai, let's see. So the law changes, it has to be peculiar. I mean, like this, how you apply the law. is to the peculiar set of circumstances and facts of every case. It's not that we can have a uniform yardstick.
My lord, I brought it to your lordship's notice, my lord, that there is
No, that is
illegality.
what- no,
There is
there
illegality,
might
my
be
lord.
illegality, but whether that illegality is enough, to totally, make the whole vitiate the entire process to such an extent that it offends, like.
My lord, it is only on ground of illegality that the entire process can be
No,
set
but then
aside. That is the exception, my lord.
Even both the tenders
That-
also, you have not submitted. You're not technically qualified.
My lord, we have been arbitrarily rejected, my lord.
That is
My lord,
making the job very difficult.
prayer is very limited in the writ petition, my lord. They have come against their disqualification, my lord. They have not come against our
My lord,
qualification.
I have
my lord.
filed my rejoinder.
They have to file a separate writ petition for that, my lord.
After the minutes of the meeting have been enclosed on the counter, I have filed my rejoinder. I have pleaded, my lord.
Will you
No
examine?
rebuttal.
There's
No
lots
rebuttal.
of-
Deeply.
Mr. Shilai, you're not filing bullet points? No. You won't file, Mr. Shilai. Yes, you are
My
very
lord,
confident.
My lord, for my application for vacating the stay, my lord, I pleaded all these aspects, my lord. Kindly take into consideration.
That will take together. We'll consider it at that stage.
My lord, as far as 25, so Mr. Sangreso's case, my lord, we have not yet filed affidavit.
No, state has filed a lot.
State has filed.
We filed the affidavit.
It may be heard sometime next week, my lord. Or as per your lordship's convenience.
In my case also, in that case, stay may be covered.
Our stay is already operating while this matter is CAV. Nothing stay over a stay. Minus is plus, you know that.
If lordship segregate those two matters and leave my petition alone,
Accepted the tender, my lord. Accepted the condition, my lord.
there will be a problem.
How is seeking to, to sustain your petition?
Oh, my lord, that I'll satisfy.
You have already accepted your 25%. Then?
Therefore, I'm ready to satisfy even now, my lord. I'm ready.
Was the allocation of 75-25 done by the tender committee?
Nothing at all.
Or by whom?
But now, state has filed affidavit, my lord.
By the government.
No NIQ says.
But the corrigendum says that as per the policy decision, it was given the earlier notice inviting tender. Then corrigendum was issued with regard to that percentage.
A certain clause, your lordship, that corrigendum has been made with respect to certain clause in the first writ petition filed by Meenakshi, your lordship.
Yes. Corrigendum was made, but even the corrigendum touched that aspect also with regard to percentage, I think.
Right.
Lordship, I can see in the case of Meghalaya, your lordship, on 412, your lordship, that order of allotment has been made, your lordship.
No, why? Only the thing is that even though it maybe the court not have that to go to that extent, why have you made, if the rates are exactly the same, why 75-25?
But look at
What
the
is
financial
decision-making
capacity.
process in arriving at that?
Financial capacity of both the parties, because their turnover past experience only 9 crore rupees, my lord, whereas ours was 33 crore rupees, so it is divided in that proportion.
My financial turnover is much higher than the respondent. He has a 1 year experience, whereas I have more than 3 years experience.
We're not going to go into.
And my lord, therefore, no materials, my lord, no materials cited for the financial turnover.
You file the affidavit, we'll have it.
On 10-12, your lordship, he executed the agreement, your lordship. He filed a writ petition. He concealed that agreement, your
there's no
lordship.
concealment. I have an ex, but that copy was
That's the big hurdle you have to climb.
My lord, that was escaped from annexing. Other petition we have annexed.
What is it?
Voluntarily.
Under the Indian Contract Act.
My lord, therefore, I'm ready to satisfy my lord. Since the lordship take together, in fact, I'm also ready. State has filed affidavit.
File civil remedy.
State has filed affidavit. No NIQ, my lord. No NIQ contemplates or conferring power to the state government to allocate. My lord, tender value of 69 is only for the tenderers, to be decided by tenderers, my lord. And tenderers have decided.
Why do you accept the 25%?
My lord, there is a case law.
Why?
There is a case law, my lord. In contract also, my lord, party can accept party or party under protest and assert.
In the bush.
Reserve their right to assert. I'll place the judgment, my lord.
So first grab that,
only my method, my lord.
grab 25% and then
Three more term may be covered.
Wait, hearing concluded, judgment reserved. So, and in the this other matter is item number?
Item number, my lord.
50. 54. 54.
37 of 2025.
Number 37 of 25. That's your writ petition.
My writ petition.
Only one petition is there.
Only one.
Only one, your lord.
Yes. I can find.
In 5 minutes.
See, last date is made clear. There will be no further adjournment.
Exactly. Therefore, I prepare for a hearing to advance my lordship permission.
State as file, Your Lordship, the affidavit.
Start.
Well. I'll not take a long time. Only two
So
issues.
the beneficiary, Mr. We'll take it last order then.
Yes.
Yes. Oh, the last. Okay. It's the last order.
Madam.
Yes.
May I proceed?
Yes.
My lord, only the two issues, my lord, raised by me importantly, my lord, the reason for 75 in 25 allocation, that's I challenge that one. And second issue, as lordship pointed out, how can I overcome when I accept partly under protest, whether I'm still eligible to assert my right or not. But to satisfy the second point, my lord, may I place the first point, so then, my lord, I will refer to certain annexes and point, and I will straight come to the second point immediately. My lord. Now, the NIQ, my lord, clearly spell out in page number 17. NIQ, either general terms and condition, my lord, technical bit or financial bits, never stated that the allocation of the tender work will be done by the state government. Nothing. It clearly spell out that the work tender value will be, my lord, decided by the tender committee. And now, imagine, my lord.
Where does it say?
My lord, the approximate tender value, my lord, page number 17. Yes. Now, then I'll come to page number 21, financial bits. Because I'll not enter into the technical bit for the time being, since both of us has successfully crossed that one. Page number 21, the condition number 3, it says, the rate quoted by the quotationer is in the same stage. The provision of the clauses and substance of the 2020 shall apply, and the decision of the tender committee will be final and binding. Now, if we go by that, but page number 20.
Under the heading, financial bit, right?
Financial bits. Yeah. Now, under the policy, my lord, if this is continued to apply in the tender process, under the policy, they can go for 25 into 75, or 75 can be given to me also, my lord. But now, knowing very well that this is no longer, my lord, sustainable, practicable, therefore, by virtue of the subsequent corrigendum, may come to page number 33, my lord. By second corrigendum. Second corrigendum, page number 33. The last one, clause, financial bit. Now they quoted the earlier one. Now the amendment was introduced. If the rate quoted by the quotationer is in the same stage, the decision of the tender committee would be final and binding. So micro policy is no longer applicable. Now, knowing this, my lord, the tender process continued, and tenderer has decided that both of us are both financial and technical bits succeeded. But no way, my lord, tender committee decided allocation would be given 75 to the respondent number 4, 25 is given to me. Nothing, my lord. So now, by virtue of this decision taken by tender committee, my lord, it is, my lord, appropriate on my part to assert, to place my before my lord, that any tenderers sitting in the armchair of a commercial prudence, my lord, would expect that fair treatment would be given to both the parties. Now, what happened? The tender committee, after closing the tender process, that was taken over by the state government. I'll come that power of the state government. Now they have come up with the allocation, 25 into 75. Now, my humble contention is that state government has taken over, diluted the decision of the tender committee, and usurped the power of the tender committee, and control it, and, my lord, issue the allotment order. Now, allotment order, may I come to page number 34?
34.
34, my lord. 34. 34 is the allotment order with in favor of respondent number 4, and 35 is mine. My lord,
power roofing.
my
Lord
power
order
roofing.
This is for the respondent
Yes,
number.
number 4, my lord.
And then the next one, 35 is?
Yes, number writ petitioner.
You're the petitioner.
Yes, my lord. So work tender value, my lord, 53 crores, 2175 was given to the other side, and to me 1643, with a variation of more than 18 crores. Now there is no reason reflected, even in the work order, as to why petitioner deserve only 25. As to why, my lord, allocation of 75% will be affecting the public interest, it is not there. As to why 75 allocation given to the respondent number 4 will advance the public cause, it is not there. No reason. Both sides, no reason given. My lord. It's very clear. Now, if reason is not reflected there, my lord, one would try to discern from the tender process, but whether this is discussed, deliberated on by tender committee. Because the tender committee is the absolute authority to ascertain who is suitable to allocate 75 or 25, even if, my lord, allocation division is permissible. Now, it is not provided there. Now, in view of this, my lord, may I just refer to the additional affidavit filed by me, bring on record the tender committee minutes.
1 second.
Madam. Since the tender document was not privy to me at the time of filing the petition, my lord, I brought on record, madam. I filed on 4th March 2024. Yeah, yesterday. Madam, but the tender minutes would be available from page number 10 onward, my lord. And actually, 1A, my lord, I tender my
A1.
A1, my lord.
Page
The
24.
type copy, my lord.
Additional affidavit.
My lord. Additional affidavit.
Yeah.
My lord.
Yes.
Yes.
That means,
This
sir, to the state.
14 this November and
20th November.
20 November.
14th and 20th, okay.
Yes, 2 days, madam. And may I come to, my lord, page number, the A3, the next page. My lord, may move forward. A3,
Yes.
the final decision. So number 3 and 4 are the successful tenderer. They have qualified. And may I come to, my lord, A4, my lord, the next page. The deliberation of the tender committee. A4, my lord. In A4 on the top one, in pursuance decision of the tender committee held on such, the department tender committee was reconvened on such. After brief welcome from the chairman to all members and appraisal of the minutes reported and decision taken in the last sitting of the committee, inspection cutting of all aluminum sheet as submitted by all bidders were undertaken. The committee members noted that the samples submitted by all bidders conformed with the specifications prescribed in the NIQ. After thorough deliberations and evaluations of the eligibility criteria on all aspects relating to technical bids, documents, certificates, etc., which were expected to be submitted by concerned bidders who bidded as per specified terms and conditions stipulated in the NIQ, the following were the decision. The committee members recommended MS Sunset Power Roofing to qualify the technical bids and shortlisted for opening of their price bids document. The price bid of Sunset, Manaxis and Sunset are to be returned unopened by the tendering authority to the parties concerned. Later, the tendering authority, through the Director of Housing, informed the department committee that representatives of both the recommended and qualified bidders were intimated and called and have expressed their willingness to be present in the opening of the price bids. The committee members therefore authorized the tender authority to open the price bids document in presence of all the members of the tendering authority, departmental tendering committee, and the bidders or the authorized representative. A perusal analysis were taken by the tender committee of the price bid documents, rate coded by the two qualified and recommended technical bidders. Based on the price coded, the committee members recommended the following firms company to have qualified as approval supplier as per the rate indicated against each matter. So both of the quotations are there, matter. Now, As there was no more agenda for discussion, the meeting ended with vote of thanks from the chair. My lord, my humble submission is, my lord, I want to bring home the point, lordship, that there was no deliberation at all about the allocation of 75-25 or 50-50. Now, tender committee has the power to take a final decision, and the tender value is 69 crores. If the tender committee adopt a resolution that it should be 75, 25 or 50-50, that is the prerogative of the tender committee as per the court injunction. Because once both the parties cited the same quotation, decision of tender committee is final. It never spell out that, my lord, decision of the government will be final. Nowhere, my lord, general terms and condition, technical as well as financial bids, nowhere, my lord, the hand of the government is allowed to enter. It's purely the tender committee. So therefore, allocation given by the state government, I'll come to that affidavit, my lord, is absolutely untenable, my lord. Now, may come to page number 14 of that very additional affidavit, my lord. Page 14, my lord. Annexure B. My lord, may I read, my lord? Now, this is written by the government to the director. With proceeding of the tender committee held such and such. With reference to the subject cited above, I am directed to inform you of the Minister in charge Housing Department approval of the recommendations made by the Department Tender Committee as per proceedings stated such and such, enclosed herewith, with the request to initiate steps for submission of proposal for allotment of work order to the approved supplier, preparation of the target of beneficiaries per block per urban committees, intimation to the approved recommended supplier. Further, the target work out on number of beneficiaries per block or urban area to be allotted prior approval of the government and minister has to be obtained. This for information. Now, this one, it indicates that, my lord, the entire tender proceeding has been taken over by the government and final decision was taken by the government. Here also, it did not spell out about the allocation. Who has allotted? It didn't say, my lord, minister in charge has allotted 75 into 25%.
It's with reference to, so the minister in charge has approved the recommendation. It's just recommendation by tender committee. They are the owner of the work, the government, and so that's approved by them. Fine, they said it's all right. And whatever happens is administrative action after that. It's not connected to the tender process. That you to initiate steps and to identify.
Yes.
That's totally different.
No.
What only thing is that what this letter indicates is that they've accepted the recommendations of the Department and Tender Committee. Finished. That's it.
But now, my humble
what else you want to show?
Now, my first limb of argument is that, my lord, the tender committee, under the NIQ, since the tender committee is the authority to decide the suitability of the tenderers, my lord, tender committee has adopted the decision equally. If it is taken, the decision was equally, my lord, the allocation is supposed to be equally.
That's it. That's the only submission.
Second,
that,
my lord,
see, tender committee has not has not deliberated on the question of the proportion. They only examined the suitability of the tenderers, found you and the respondent number 4 to be suitable, and they submitted the thing to the government. So government has said, okay, fine. They accepted the findings of the recommendations rather of the tendering committee, and subsequent action to be taken. Now come to that part where 25-75. Now you come to that part. Now that part you say that since a tendering committee not deliberate or discuss it, that means this is arbitrary.
My lord.
That's all.
My lord, we can, lordship permission, I can take one example. If out of 4, only 1 person is successful tenderer, but allocate, there is no question of division of allocation. My lord, tender work tender value will go to the successful bidder. Now it comes to the, my lord, since 2 tenderers were selected,
okay,
the question of proportional.
Yes, fine. Proportion has been done. Where's the order giving proportion? Where have you annexed it?
My lord, nothing is, my lord.
No, that order saying 725, where's that order?
My lord, there is
that
no
is
such.
R4. That is your page 34 of your.
Page 14
sorry,
is there.
Page 35 of your.
34, 35, your lordship.
Yes, okay, fine. So that you say is arbitrary is been done by the department itself, correct?
Yes.
Not the tender committee. That's the only thing. Now you have to meet the argument that although you feel that this is wrong, you're both on the same level or same price. Then why did you accept? Why did you sign an agreement?
Just 1 minute before I reach to that point, my lord. First, I question
that's all,
I'll come to that one.
Yes, why do you accept it? That's all court is why accept it, and now can you turn back now?
My lord, just something, my lord. Tender committee is expert authority, have decided
Fine.
equally.
Why didn't you make this point? You should have rejected the offer.
I'll come that one. That is, I have to
and say the protest, and you file a petition.
My lord, that
then,
I'll come.
Then once when did the order come? 34?
My lord, I'll come to that point. See. My first contention is, my lord, it is a tendering authority, tender committee only who has the power to decide.
Right. No, that
second is, my lord, the state has no power to allocate.
This allocation was done as far back as 14th November.
Yes.
No, 4
December.
4 December, Your Lordship.
I'll come
Not
to
14.
14.
4, Your Lordship. Lordship, kindly come to page 36 of the writ petition, Your Lordship.
Yes, 4th December. Okay.
4 December, Your Lordship. Yes.
4 December.
4 December.
4
December.
Lordship,
The allocation was done
Lordship,
of
yes.
16 crores for you and 53 crores for Mr. Dr. Mohammed.
Yes, the respondent.
Right. 4 December.
Yes.
Same date given to power roofing, same date given to you.
Yes.
Then what prevented you from coming to court at that point of time?
Now, my lord.
So once you have not come to court, the doctrinal waiver will apply.
My lord. Therefore, my lord, if lordship can see page number 41.
And you entered a complete contract. You've signed it also.
My lord, that is
how are you going to beat that?
My lord, the contract, my lord, the contract.
Okay, very well and good. Whatever you've shown, there is some irregularity at the face of the record itself. With regard to the committee minutes, do not show there's any discussion. Although the corrigendum provides that decision tender committee shall be final. Only thing you've shown is that fine, the minister or whatever has accepted the recommendation tender committee, and you have accepted 5%. That's the case. Finished.
Therefore, my lord, my protest letter is page number 41. Immediately, my lord. Immediately.
When did you sign the contract?
My lord, 11 is my protest letter is on 10.
When do you sign? When you sign the
11, the next day itself.
11,
within the confines of the protest letter.
412 is the.
My lord, kindly see page 41 of my protest
11,
letter.
1 second. 412 the letter of invitation, right? Now, when did you receive it?
My lord, that one, my lord, there's no specific. It just come to the government with regard to that.
No, on 11. Lordship, there is an affidavit filed by the state. If Lordship kindly come to page 8 of the affidavit filed by the state.
Protest letter is at page 41.
Yes, my
lord.
41.
See, first let me thank you for the supply orders. An agreement copy do you see and signed by us is enclosed. So you sign and enclose that. Hence, however, like to highlight the following points, if I can.
Yes, page number 41.
Lordship will kindly
Now,
see also the date, Your Lordship. The date is very important, Your Lordship. 10/12/24, Your Lordship. Yes. This is the protest letter, and on 11/12/24, the agreement was signed, Your Lordship. He protested but signed the agreement.
When this is dated?
Protest letter is page 41.
Page 41, Your Lordship. On top, Lordship kindly come on top date.
I don't understand. Is acceptance? This is the wrong date of 4th December. That means. Yes.
4th December, Your Lordship. Yes, 4th December.
Not 14th.
Not 14, Your Lordship. Yes. Lordship kindly come to page 41. That protest letter. At Lordship kindly see the date. 10 December 24. Then.
Yes. That I don't dispute.
Lordship kindly have a look at the affidavit filed by the state, Your Lordship.
My lord, learned EAG will give me time to place my case with due respect.
But that was running the mind of the court.
My lord, that I have to.
You can't have your cake and eat it too.
I have to satisfy that point, my lord. Now, this letter was written on 10 December. Yes. With regard to the date of receiving the supply work order, I'll just ascertain it, my lord. Give me some time. This was received by the authority on 11 at the bottom. And the contract agreement was executed. I have annexed in my petition, in my additional affidavit, which my lord has gone through. My lord. It was signed on, my lord, page number 15 onward.
Page number?
15 of my additional affidavit.
December.
15, my lord. It was executed on 11 December. And this the format of the agreement is lifted from the NIT only. Now my contention is that this agreement was entered within the confines of my protest letter. Well, I made my position very clear on 10 and received by doctor on 11 that I accept this 25 under protest. And they ended this.
It's not land compensation where there'll be reappraisal enhancement.
I'll place a few decisions, try to persuade.
You're talking about commercial law.
It is a commercial law. I'll cite one or two
cite
judgments,
yes.
but where in the commercial law also, my lord, parties were under protest participating in the tender process.
Authorities.
And the other side argue that I suppressed this fact. My lord, there's no question of suppressing this fact. It was accepted at the time of filing the petition, and annexure was escaped from the mind of the petitioner. I brought on record immediately in other petition also, and here also. There is no question of separation of facts. Now, the affidavit, before I go to the citation, if Lordship permits me, few paragraphs of the affidavit filed by the government, and I'll go to the
Okay,
citation.
what do they say?
My lord, the counter affidavit filed by the direct government. I'll come para 8, 10, and 12 are relevant.
6 is the most important.
6 also they raised, my lord, that is misleading, that I suppress those facts. These are there. I'm answering them.
Now, what do you want to show from the affidavit?
My lord, para 8 may, Lordship, can come para 8. In para 8, they said, my lord, that the apex court has also held that if the decision relating to award of contract is bona fide in public interest, court should not interfere. The rationale of having an empaneled lease of successful supplier vendors bidder is on a need basis. Such empaneled supply vendor cannot challenge the issuance of supply order contract based on their desire. It is the government's prerogative to award the allotment to any successful bidder, and the latter cannot claim equality of allotment as a matter of right. But as such, there is no such discrimination violation. So they say that it is a prerogative of the government.
What do you want to show from the affidavit?
My lord, the ground taken by the government.
That is just, they're just citing following Supreme Court decision that.
My lord.
Yes.
And Paraten also, my lord, they admitted, my lord. It is administrative power.
Where have they said about that? What you're advocating regarding or arguing that tender committee did not consider it, and where's that?
Well, my lord, become regarding that relevant portion. Paraten, my lord.
Yes.
But since the answering deponents state that the firm of the petitioner and the respondent 4 were both found to be technically qualified and also quoted the same financial bid, and as such, the two firms were recommended and approved as supplier. It is pertinent to state herein that
Minister of Housing.
allotment of
Lordship.
The minister made allegation.
I'm sorry, Your Lordship.
You've written affidavit. The minister has made allegation.
Where is it?
Yes. How's head of department minister?
Lordship, there is a memorandum, Your Lordship, office
He's
memorandum.
head of department.
Lordship, yeah, because this is above 50 lakhs, Your Lordship, so the approval of the minister in charge is required, Your Lordship. That I'll please, Your Lordship. That I'll please, Your Lordship. I'll please it.
The decision also that even if minister, the decision of a minister is not binding on the department also, you know that.
Lordship, if Lordship kindly is.
You know that. Suppose a minister, Mr. Sholai and Mr. Changreso, you're both tenderers, and you go and approach the minister. You suppose Mr. Sholai, he makes a noting there, no, please award contract in favor of Mr. That is not binding also.
Lordship,
even
there
the
is
ministers cannot be held culpable for such notings.
There is a office memorandum, Your Lordship, of 2002, Your Lordship.
Okay.
Lordship, kindly come to page 5.
No.
Approval of minister.
It's not a question of approval. It's a question of decision making. Approval, decision making are two different things. Now, approval. Suppose you put up a proposal
Lordship,
that's approved.
Because
now you've written in your affidavit, the decision regard to the allotment supply lies with the head department, the head of the minister. The proposal has to come from the department itself, and the minister to see whether he approves the decision or not. Not
Lordship,
a question
yes,
of
the department put the proposal before the minister.
where's the proposal.
Approved, Lordship.
Now you've written here In the
No, Your
affidavit
Lordship, it
itself,
is
it
not
said the
written.
function of tender committee is to approve the bidders. Fine. The decision regard to allotment, supply, or the head of the department.
Yes, the department, Your Lordship, placed the proposal before the.
Where's the proposal?
It is not. It is not there, Your
You've said
Lordship.
an
in the
affidavit that he does allegation. That's why
It's
this
not.
court is saying that the minister does not do that.
But approval of the minister in charge is required as per the recommend of this office memorandum, Your Lordship.
Like approval is different from allocating. What is the executive function, and the approval of the minister is as what authority?
Because the department will place the proposal, Your Lordship, and then.
Where's the proposal? You've written here in the affidavit itself, the function tender committee approval, the decision with regard to allotment, supply, order lies with the head of the minister.
It is not written, Your Lordship, but the decision is there, Your Lordship.
Anyway, we'll not go into that, but the minister is not the person to make the allocation, to say give this much, this much. He's a politician.
Lordship.
The executive function lies with the department itself, which has to assess, as that letter says, how much tin will be given to one district, so on and so forth. That's all. Yes.
Madam, at the bottom in the same paragraph, my lord, it is settled law that it is open to the government to choose a person of their liking to fulfill contract which they wish to perform. A location of work was made in public interest and based on administrative discretion, which is the prerogative of the government to ensure timely completion of census. But throughout the
So where's the part where the answer that the tender committee had decided for this 75-25 in the affidavit?
My lord, they did not spell out regarding that part.
Then the affidavit is neither here nor there.
Yeah. Now they say in the affidavit
Anything
also,
else?
my lord, the ground, my lord, the reason why allocation is given to others 75 and 25, no reason even disclosed in the affidavit.
They've not answered that.
No answer, and no materiality, no annexures, no Lordship has correctly pointed out, no proposal to commence. So on what basis, my lord, the head of department, accepting that it is correct, head of department apply its judicious mind to divide 75 into 25? There is no material such. Therefore, it is an unbridled, my lord, unregulated exercise of power by the head of department, so-called, my lord, which is not sustainable in law.
No, Mr. Shulai, you need to substantiate as how the 75-25 was done. On what considerations?
Let him finish,
Under
Your
what
Lordship.
authority? You finished? Yes. The word authorities, you said regarding that backtracking from your concluded contract.
Well, so
executed contract.
I'll cite a few decisions.
Just give me 5 minutes, yes. Interesting case. Okay.
My lord, this is this citation. My lord, I have submitted list of books, citations, my lord.
Yes. Citation.
Citation. My lord, number 1 to 4, last time I've cited already to satisfy my lord, to exercise lordship tender jurisdiction under what circumstances, my lord. Number 1 to 4. So I'll not trouble my lord.
1 to
again.
4 is?
1 to 4, I have already cited last week. So
Regarding?
I will not my lord, repeat again. And number 5, my lord.
No, regarding 1 to 4 is regard to discrimination.
With regard to my lord, under which my lord circumstances lordship can exercise your lordship tender jurisdiction.
You not give the name of the parties, but when you give list of book, at least if you give a list like that, so at least give the list of name of the parties. So at least when I look, I'll know which case you're referring to. I meant no citation, but the name of the party will be familiar.
But we will keep my lord subject.
Yes.
Now number 5, my lord, it is with regard to unbreathed power and application of mine. But with regard to this, my lord,
Which one is 5?
Number
2010 volume 9.
No, I have only one copy. Which one?
10 volumes. Number 5.
volume 9.
Yes.
Relevant para would be 22, 28, and 29. May I just straight to go to 28 minutes to save lordship time. Para 28.
No, sure, para 22.
Well, 22 also, and 28.
Okay, 22 and 28.
In light of the above pronouncement, unnecessary to say anything beyond what has been so eloquently said in support of the need to give reason for orders made by courts and statutory or other authority exercising court judicial function. All that we may mention is that in a system governed by rule of law, there is nothing like absolute unbridled power exercisable at the whims and fancies of the repository of such power. There is nothing like a power without any limits or constraint. That is, so
No,
even
no, these are general principles.
General principle, my lord.
What a judgment you have,
My
which,
lord.
which is a bearing on your case.
My lord. So I
Put
want.
out from the list.
I'm citing this judgment with regard to the point that government has exercised, my lord, power.
Your point with regard to backtracking. I want that.
With regard to that, one may straight come to item number 8.
Okay.
First,
Allahabad.
division bench of the Allahabad High Court. Then I come
That's
to Supreme
important.
Court.
Yes.
But as to whether the concept of my lord protest
Reason
under protest.
there are n number of decisions.
Yes.
With reasonableness.
Well,
that is.
Well.
Yes.
Well, this way I take my lord the. Yes.
Para?
With para 6 to 13.
Yes.
Here also, my lord, they used the word under protest, and the intent of the party was, my lord. Now, may I start from para 6?
Yes.
My lord. For the appellant, it was argued that the signing of the no-claim declaration and the grant of a full settlement receipt was in law the discharge of the contract. The contractor would not thereafter raise any dispute as to the payment under the contract. With the discharge of the contract, the arbitration clause extinguished and no alleged dispute could validly be rendered to the arbitration. It was urged that the endorsement of under protest made by the appellant on the bill did not change the situation, for the appellant reliance was placed upon words and phrases by the Rolling such and such. It is said that the money was received by the petitioner and the receipt given under protest. These words are often used to these occasions, but they have no distinct technical meaning unless accompanied with a statement of circumstances, showing that they were used by way of notice or protest, reserving to the party, by reason of such circumstances, a right to a taxation, notwithstanding such payment. The words have no distinct meaning by themselves, and amount to nothing unless explained by the proceedings and circumstances. In this book, reference has also been made to such Madras to the effect that the value of the phrase under protest is to safeguard the disposition of the person who makes the payment and to ensure that it may not be said that the payment he made was a voluntary one. According to observation, significance of under protest has to be judged in the context of the prevailing circumstances. In the Madras case, the protest was made by the person making the payment. It was held that where a tenant pays certain rent under protest in pursuance of the demand for excessive rent, and it is found that the demand is illegal and unreasonable, the tenant is entitled to refund of the amount which was not legally due to the landlord. In view of this decision, the making of the endorsement under protest is to safeguard the position of the person making it and to ensure that it may not be said that he was doing the act voluntary. In the present case, none of the parties led any oral evidence. The endorsement of the under protest has been made on the final bill. We have to construe the document in order to ascertain the intention of the contractor in making such an endorsement and of the company in permitting such an endorsement to be made. On such, the contractor signed the no claim declaration as well as the receipts for the money found by the company payable to the contractor and made the endorsement of the protest. The contractor was disputing the correctness of the calculation of the manager of computing the amounts in the final bill. He was not disputing that the amount calculated by the company as payable to him was due to him. He was claiming much more, and therefore he could not possibly make a protest to the receipt of the amount specified by the company. The grievance was that the payment was less than his demand. He is making the endorsement that he was receiving the amount under protest could only mean that he was challenging the correctness of the bill and that he was preserving to himself the right to question it. The endorsement dispelled an intention to remit the performance in regard to the balance of his claim. It claimed the evidence that the receipt of the amount was not unconditional so as to effect a discharge of the contract. On the contrary, it safeguarded the position of the contractor and indicated that he was not accepting the payment without any reservation. My Lord, I come to 10, my Lord. Learned counsel for the respondent company, however, has invited our attention in the decision of the Supreme Court in the case and such. In that case, the appellant at first gave a receipt stating inter alia that he had received a sum of rupees and such in full and final payment of the balance of the rupee 20 and such allowed by the government in respect of his claim 30 and such, reserving, however, the right to recover the balance amount to him under the said pronote. The authorities, however, refused to make the payment on such a conditional receipt. Thereupon, the appellant recorded a satisfaction of full payment and granted the receipt, which unconditionally stated, receive payment in full. The Supreme Court held that sections and such of the Contract Act, read with such and such appended to that section, apply to the facts, and the appellant having accepted payment in full, satisfaction of their claim were not entitled to sue for a balance. It will be seen that in that case, the payment was accepted in discharge of the whole claim. At the same time, of the acceptance of the payment, to condition or reservation was made. In the present case, the appellant specifically stated that he was receiving the money under protest. That was clearly making a reservation, and the reservation could only be that this acceptance of the payment was not in discharge of the contract. Consequently, it cannot be said that the appellant dispensed with or remitted the performance of the contract for the rest of the dues. My Lord, may I come to, my Lord, applying this principle, we find that there was no record and satisfaction in the sense of bilateral consensus of intention. The appellant made it clear that he was accepting the money under protest, that is, conditionally. Under the circumstances, it cannot be said that signing the no claim certificate and the grant of the receipt amount to discharge of the contract. So the concept of the importance of under protest, it can be discerned under the prevailing circumstances, my Lord. So he has reserved his right when he accepts the contract from the authorities. So similarly, my Lord, in my case also, put on the judgment that when he put up the protest, he reserved his right, my Lord. He is not voluntarily surrendering his right. Another one, my Lord, the 1987 supplementary, my Lord. That is item number 9, citation. Page, my Lord, page number 127. My Lord, I'm trying to persuade, my Lord, the concept of whether the concept of under protest or conditional acceptance in tender process is permissible or not. My Lord, 127. Para would be para 2. My Lord, it's a short judgment maker. My Lord. So far as the second point is concerned, the argument of the learned counsel for the appellant is that the acceptance of the tender by the chief engineer was a conditional one. Reliance has been placed in this context on the letter of acceptance, which is quoted hereunder to the extent.
Where reading from?
Para 2, page number 129.
Oh, understand.
Well,
yes.
So far as the second point is concerned, the argument of the learned counsel for the appellant is that the acceptance of the tender by the chief engineer was a conditional one. Reliance has been placed in this context on the letter of acceptance, which is quoted herein under such. Your tender for the above service for the lump sum of rupees such is hereby accepted by me on behalf of the President of India. In accordance with condition number 6 and such, you are required to lodge with JE of rupees 700 as additional security within 30 days from the receipt of this letter. But the High Court has read this letter of acceptance as one of the unconditional acceptance of the tender. The demand for deposit of rupees 700 as additional security was a request made in the context of such and such. We agree with the manner in which the letter has been read and interpreted by the High Court, namely that it was an unconditional acceptance of the tender. It was a letter requiring the appellant to deposit a further sum of rupees 700 after the tender was accepted and the contract came into existence. It was not obligatory on the...
No, this is not, that won't apply because this is acceptance, it is not a condition at tender, so he is not compelled.
My question. But what I'm trying to hear narrowly is that, my lord, the concept of acceptance under protest, unconditional acceptance is permissible in the tender process, my lord. That is what I'm trying to persuade, my lord. That is the... So my protest, my lord, though I have no fundamental rights to accept the, to get the contract in my favor, but it is the fundamental right of all the tenderers to put up a protest if they find it aggrieved, my lord. Now he has exercised that one, but so the protest, protest application put forward by him is in consonance with law. This is my humble submission, my lord. Another judgment, my lord, the number 6, my lord, number 6 in the citation paper. But 2010, volume 3, page number 732, para 41. My lord. This with regard to aspect of the, another aspect, my lord. Because no reason has been given by the government with regard to the 75 and 25%. Para 41, only short para. Para 41. Well, reason is the heartbeat of every conclusion. It introduces clarity in an order, and without the same, it becomes lifeless. Reason substitutes subjectivity by objectivity. Absence of reason renders the order indefensible, unsustainable, particularly when the order is subject to further challenge before a higher forum. There is no reason spelled out in the any materials or even in the affidavit as to why, how they reach a conclusion of 75.
Yes, again, this is against an order of the High Court. Without which was part of reasons. See in the head note at the, this one is that the High Court recorded reasons for granting permission for construction. That's all. That is the only thing. Anyway.
But that is a general law, man. In the last citation, may I please,
general law means it talked about executive decision subject to judicial review. Yes. And if the thing is that we have question decision being processed also, that is, it is what you call not in consonance with the tender NIQ, and the decision has been made, arbitrarily by some other authority.
Yes, some other authorities.
But the fact remains that you accepted it. Yes.
My lord, that one I tried to
convince. Only Allahabad decision, the only one you've shown.
That one is
because that also was a contract where there was a procedure for arbitration, but they said that if you receive payment in full and satisfied, that means if you write under protest also, now you can't ask for arbitration because there'll be no arbitral dispute because your contract's already fulfilled.
My lord.
Correct.
My lord. Section 60.
But there in that case is inbuilt mechanism in the contract itself with regard to for arbitration, which the owners of the works said no, you can't resort to arbitration any longer. So this in that Allahabad decision decided that fine, and whatever the other protest, there's still issues that have to be decided, and since arbitration clause is there, which is sought to be disallowed by the other party, then the matter was referred to arbitration.
Right.
See, it is not the case here.
But what I'm trying to
The
bring.
case here is not a question of any arbitrable dispute. The question here, or any dispute regarding the quantum of payment. Here is a clear-cut case of, like, you know exactly where you stand with regard to the granting of 25% of the contract itself. Because you know 69 crores.
Right.
Right, the full value of the contract. Right. And the letter of allotment given for 16 crores. So straight away, you know that you've been wronged.
My lord. Therefore, my case would be different if I accept without any protest and I come before my lord. I have no case, my lord. But right around my lord, he has put up his protest. My lordship may kindly appreciate that.
You can't get any more authorities.
My lord, that with regard to
I'll
that.
do my own research, but then this is an interesting point.
My lord.
Yes.
Then other point, my lord, number 7 in the citation 2010-11, with regard to superior interference by the superior authority, where exactly, my lord, the minister is absolutely taken away. All the process and decision was perhaps taken by himself. 2010 volume 11. 11 para will be 23, man. Is also with regard to, my lord, page 23, para 23, man. My lord, therefore, the law on the question can be summarized with the fact that no higher authority in the hierarchy or an appellate or revisional authority can exercise the power of the statutory authority, nor the superior authority mortgage its wisdom and direct the statutory authority to act in a particular manner. If the appellate or revisional authority takes upon itself the task of the statutory authority and passes an order, it remains unenforceable for the reason that it cannot be termed to be an order passed under the Act. It's exactly my humble submission. A minister has taken away. Lordship has correctly pointed out, head of department, there's an inbuilt department is head of department. Even head of department is not passing the order in my case, as per the statement of the respondent in the affidavit. It's done by the minister, who is the political head. So the order passed by the authority with regard to 2575.
They have not worded, if they want to word, if you said that, this department have been approved by the head of by the minister in charge. That's the thing. But then they said that he done the allocation.
Right. So my
that is one thing which
my contention would vary.
That is one thing that maybe we might overlook it or examine it closely.
My contention would be very narrow if the head of department take a decision applying certain grounds for allocating 25 and 75. Challenging that one, I have a task, my lord, to overcome. But in my case, my lord, authority has not taken decision. A stranger or foreign authority has taken the decision. That is the issue, what I'm trying to persuade, my lord. So the Supreme Court says it is unenforceable.
Authority vested with the power.
Yes.
Do not take the decision.
Yes, do not take the decision. Yeah. So the allocation 75-25 is
done by an authority foreign to the process.
Yes.
Okay.
Therefore, 75-25 allocation is not fair. Yes. And lastly, my lord, in fact, the petitioner is for the business, my lord. Even in these circumstances, my lord, what happens if the two tenderers are selected? Normally, my lord, the tendering authority allow the parties to go for price negotiation also. Price negotiation. And both the party may come down when they can select. Well,
that's a good submission.
My lord, I'm ready for that also.
That happens also. Yes.
My lord, that happens also, my lord.
No negotiation.
Yeah, no negotiations. I'm ready for that, the process also.
In that case was cited by Mr. What is that? Mr. Shilla, I think. That one regarding that other case. That those people who are on the same rate, though there was cartelization, they were called for negotiation. And a fellow who was less by 1 rupee,
yes,
he was kept out from negotiation.
Yes.
Everything, yeah.
So the petitioner, even today, he is ready for that also. But he is ready for that. Otherwise, in this
so we give 75%, give 25%. Suppose the court allows that, it's fine. No arbitrariness.
but,
yes.
So my humble submission is the action of the respondent is highly legal.
We finish it by 1 o'clock.
I made please your lordship.
You get more authorities. It's not really. Only that one part you have to see. The only most part you have to overcome that the under protest still doesn't extinguish your rights to agitate the issue.
Yes.
That's all.
My lord.
That we examine in your case.
My lord.
Your acceptance, execution of a contract under process, whatever, does not extinguish your rights.
Yes, yes, my lord. And the reason circumstances
Or
under
does not
why,
amount to waiver.
my lord, the compelling circumstances, my lord, before Lord AHA start, condition number 15 and 16 of the NIQ, my lord, clearly spelled that if I don't sign the agreement within 7 days, my earnest money of 1 crore 39 lakhs will be also forfeited, and then they will be not given to me.
See, the court always there.
Those are there. Because of that.
Come because
they come after 2 months, man.
No, my lord. The tender, my lord. The process, the protest.
You see, we can't.
I filed a tender.
You
process.
signed when you got a letter on 4th of December.
My lord, that one, my lord, I received the instruction. The work order was passed on 4th December, but it was supplied to him on 10th December.
Fine, then.
And the next day itself, he
ran
put
and
up the
signed
protest. The next day itself, my lord, on 10th December, he has redone it, and on 15th, he has signed the contract. My lord, otherwise, under condition 15 and 16, his earnest money. No, my lord, it is not 2.5.
Okay,
Immediately, my lord, we put up the protest.
May it please your lordship. Lordship, first and foremost, your lordship, is that the writ petitioner, your lordship, he cannot approbate and reprobate, your lordship, accept one part and reject another part, your lordship. Then, lordship, the petitioner is guilty of suppression of facts, your lordship, material fact, your lordship. Kindly see, your lordship.
Why you say that?
Lordship, kindly come to page 35.
Of his application.
Your lordship, yes. This is the supply order dated 4th December 2024, your lordship.
Yes.
Lordship, kindly see, this supply order is subject to your acceptance and fulfillment of terms and conditions of an IQ. You are therefore directed to sign an agreement within 7 days of issuing of this supply order and to start the delivering the material. Lordship, this is the tender. So according to the writ petitioner, he received it on 9, your lordship. Then lordship, kindly come to page 41, your lordship.
You write 7 days from the date of issuance of supply order.
Lordship, yes.
That means.
That means.
How
that
does
means
he receive it?
4 on 4, your lordship. On
9 December. 9 December.
Just now you said 10th.
No, 9 December I received, and 10 December he has written the protest application, and 11 agreement was signed.
So, lordship, then kindly come to page 41, your lordship. That is the so-called protest letter, your lordship. The date is very important here, your lordship. That is the date of 10 December 24, your lordship. 10/4, your lordship. Then, lordship, kindly come to the affidavit, your lordship, filed by the state, your lordship. Lordship, kindly come to page 8.
Page 8.
Lordship, yes. Agreement, your lordship.
Yes.
This, lordship, kindly see. This agreement is made on the 11th day, December 24, your lordship. So, your lordship, when he signed this agreement, your lordship, on 11 or lordship as submitted by the writ petitioner on 15, your lordship. So that protest letter, in my humble and respectful submission, become redundant, your lordship. It become infructuous. That means he had accepted the allotment order, your lordship, willingly.
So now your submission is that, notwithstanding the protest,
lordship,
by the very fact he went and signed it next day,
lordship, yes,
has extinguished all his rights.
Yes, your lordship. Yes, your lordship.
Protest letter
dated 10 December, 10 December, lordship.
Agreement on 11.
Agreement on 11 within the time stipulated in the allotment order, your lordship. That is 7 days, your lordship. And when he filed this writ petition, your lordship, this agreement was not made part and parcel of the writ petition. So, your lordship, this, in my humble and respectful submission, would amount to suppression of material fact.
You didn't include this.
No, your lordship. Only when the state filed the affidavit raising this contention, your lordship, they filed that additional affidavit, your lordship.
But we failed to annex this agreement.
Why?
My lord, that was escaped while drafting the petition. And my lord, when the other matter came up,
it is the heart and soul of the entire petition.
My lord, when the matter was drafted, there was escape. My lord. That is the matter.
There is no
Escape.
pleading also,
And
Your
suddenly, my
Lordship.
lord, suddenly, in other petition, my lord, we brought on record.
By magic.
Oh, no, my lord, we brought on
This
record.
is equitable
that we have
jurisdiction,
signed
Your
the
Lordship.
paper. We have
Equitable
signed the paper.
jurisdiction. A person who comes to the court, Your Lordship, seeking relief must come with a
yes,
clean
you know
hand,
that,
Your Lordship. Must come with a clean hand, Your Lordship.
Yes. Okay, yes, then.
So on this count, Your Lordship, on this ground or suppression of material fact, Your Lordship.
One word in the petition. Just see the petition.
No, Lordship, I have gone through the petition.
Well, that part was escape, my lord.
I
That part was escape.
I did not see, Your Lordship.
Where's that? Where? Just see the pleading.
It has not been stated, Your
Long
Lordship.
read petition. Where it comes to.
It has not been stated, Your Lordship.
My lord, with regard to signing that was a completely escape.
1 second.
Escape.
Yes. No, I did not see. I have gone. Nothing has been said about the agreement, Your Lordship.
So let me repeat some of the
Para 12.
first para is para 14.
No, para 12 is 12.
Yes, only that protest letter, Your Lordship, that they are 10, 12.
Mr. Changreso, this is very serious.
Well, that part, my lord, my lord, we did not
It
make.
is not that the government.
But immediately other
It is
connected
not that
matters we brought on.
the government, Your Lordship, keep this agreement in the pocket, Your Lordship. It has been handed over to him, Your Lordship. He concealed, Your Lordship.
He doesn't make any pleading at all.
There is no pleading to that effect, Your Lordship.
Even you allude to the fact that the agreement was existing, maybe anyway.
Only when the state filed the affidavit, Your Lordship, raising this contention, Your Lordship, that suppression of material fact, Your Lordship, the additional affidavit has been filed, Your Lordship. So my humble and respectful submission, Your Lordship, on this count, the writ petition, Your Lordship, is liable to be dismissed without going into the merits of the case, Your Lordship.
Yeah, Dr. Mazika, you don't think you have any assumptions to make?
My lord, only two aspects, my lord. That this is a public welfare project, my lord, and it is meant for BPL families, my lord, and the monsoon is on the offing, my lord.
But even then, if that's why most of public interest, you can't have tins that are supplied to the poor BPL families that one small wind comes, they just tear up like
No,
paper.
Your Lordship, there is a specific in the
There's a
tender.
very specific
We just found that our Lordship, our
We
low
have it
quality
court
will.
monitored.
If
The
government
supply.
finds that, my lord, they have.
Where's the tin? You didn't bring it today. You know that Mr. Chidanambaram, one day when he argued a matter, happened to be in the courtroom that day. She's arguing a matter with regard to, what is the finished product and what's the unfinished product. So whether, like a piece of wood, is on tax, like where it amounts of finished product or like it's just bound together, will be finished product or in its pieces. What did he do? He bought string and he said this is the wood and he tied it in court and showed it. What's the difference between what the assessing authority said that between the finished and unfinished product? If you show the tin, where's the tin?
Lordship, that order has been stated, Your Lord, that allotment has been stated, the process has been stated, Your Lordship.
Yes, what do you have to say, Dr. Mazika?
There was one aspect, and the second aspect in the agreement, my lord, if there was anything like protest, my lord, that should have been specified in the agreement also. Because it is signed on a subsequent date, my lord, it will presume that supersedes that protest, my lord.
Become redundant.
And the writ petition has come to before this honorable court after 2.5 months, my lord. Writ petition was filed on 26th of February, my lord. They signed the agreement on 11th of December. Exactly 2.5 months.
Yes.
That's
We'll see.
My Lord, may I just point out, my Lord, with regard to agreement, the copy of the agreement was not given to the petitioner. However, my Lord, that vermin is not there specifically in the petition. I admit, my Lord. The copy was not available to him. Now,
it's not available in the sense that
copy was not given to him.
Only one agreement was signed.
One agreement was signed, retained by the department, not given to him. Now, other case, my Lord, to connected matter, that issue came up. We brought on the court also later on. So there is no deliberate separation of facts. There's no separation of facts.
At least you alluded to it. Even you don't have the copy. You should have said that we signed an agreement. We have not received every right. You write in all the provisions that we signed the thing, but then that is not available to us. We be permitted to produce it as and when we get our hands on it.
Right. That is one of the key points. We would have make at least a vermin also. That is true. But there is no willful separation.
Hearing supplementary list, item number 3.
Where's MS Piangi? Yes, Mr. General, what submission I have to make? We have heard Mr. Query.
Lordship, I'll just take 2 minutes, my Lord. My Lord, yesterday, during the course of yesterday's hearing, Lordship had correctly observed that as on date there is no impugned order as such against which Lordship has, on which Lordship has to apply his mind. So Lordship, the matter can be disposed of with Lordship expecting or expressing Lordship's desire that the proposals that we have submitted may be processed strictly as per the rules, my Lord, by the government.
Of course.
My Lord, but just
but to take into account the proposal that was submitted by the President and not by the Secretary, that aspect.
No, that's a different case, my Lord.
Oh, sorry.
That was a previous case, my Lord. No, my only request would be, my Lord, that while parting with the matter, if Lordship is kind enough to supply to also clarify a certain issue. Because it appears that the state government, my Lord, may be having some misconception about the rules. Rule 5, which Lordship had read yesterday. Rule 5, my Lord, which says that Secretary shall forward the names of the elected representatives, my Lord. Now, I'll just take 2 minutes, my Lord, on this. If Lordship looks at Rule 5 actually, my Lord, is controlled by Rule 2. And Rule 2, my Lord, I have extracted.
Where's the EAG? She's in the court. Or she's there?
My Lord, if Lordship...
By humble submission before he starts, since the director has to decide the matter of its own without being influenced or any observation, anything, then let the director decide.
Absolutely. So director will decide.
Without being influenced by any observations.
What to say?
Director will decide.
Yes, he can be free to make a submission. Court decide who wants to decide. Yes,
Lordship. Lordship, Rule 5 is actually controlled by Rule 2. If Lordship looks at my affidavit, page 4, my Lord. I've extracted Rule 2. My affidavit in opposition, Respondent 4's affidavit.
Okay, yes, got it.
So, page 4, my Lord.
Yes.
Page 4, Rule 2, I have extracted, my Lord. I'll just read. Save in cases where the director sanctions a special committee under special circumstances, each managing committee shall consist of 1 president and 1 secretary, both of whom shall be nominated by government, and 10 ordinary members, except in cases of middle schools, where this number will be 9, which shall include the headmaster, and 2 members, except in case of middle school, where the number shall be 1, to be elected by the teaching staff, excluding the headmaster of the school from amongst themselves, and 5, 2 members to be elected by the guardians.
One thing regarding this part, regarding the present secretary, there was not a matter where this thing had come up. And a clarification was given that the government does not exercise this option anymore for some reasons, if I correctly remember. And that even the president and secretary are elected.
No, there was one case.
There was one case. I think you had appeared in the matter, if I'm not mistaken.
That was disposed of.
That was disposed of course.
Yes.
Where a challenge was made that it is that the president and secretary were not nominated by the government.
No, that was, I did not appear in that, Your Lordship. This presence, outgoing secretary, who had submitted his proposal for constitution of the management committee is one Mr. Dilawar.
Mr.
Dilawar Swear.
That's a different case.
Oh, that's a different case.
Sorry,
different
this
case.
is not Dilawar Swear. Sorry, sorry.
This is different case.
I think Lordship.
Bimal Kumar Bajaj.
No,
Bimal Kumar Bajaj.
Same issues.
No,
Same issues.
maybe I don't know which case they are referring to, but in this case, Lordship, as per the Annexure 1, which I have submitted, the outgoing secretary, after holding the elections of the guardian representative, teacher representative, donor representative, they have enclosed all the proceedings herein and submitted to the district school education officer.
In fact, my lord, that is exactly my point.
Mr. General will not cloud the issue, will pass orders.
Lordship,
we have noted.
if I can just, I'll take 20 seconds. 20 seconds, my lord. 20 seconds, my lord.
4 and 5 also is connected.
20 seconds, my lord. The Annexure 1, the proposal sent by them, Lordship may kindly see, everyone has been named. President, secretary, elected members, nominated members, everyone. My point is very simple, my lord. As per the rules, elected members can be forwarded by the secretary, by them. No problem with that. There cannot be any dispute with that. As far as nominated members are concerned, their suggestions cannot be looked at by the government.
That is
cannot be looked at as per the rules, my lord. As per the rules. As per the rules, my lord.
It is the director who decides these matters because
Director
it is
decide, but as per the rules, my lord. And
as per the rules.
My last submission, my lord. Because yesterday an allegation was made that my proposal is not as per typed copy, as per type form. Now that type form, my lord, is very interesting. If Lordship looks at my affidavit again, type plan, my lord.
Yeah.
Page 50 of my affidavit. 50, my lord. This is the type plan. And according to them, my proposal is not as per the type plan.
Okay.
Now, Lordship may kindly see the type plan. Type plan for the Constitution of Managing Committee of Secondary School, President, Secretary, Joint Secretary, Teachers Representative, so-and-so, Guardians Representative, Donors Representative, nominated members, they are there. Now, government is insisting that every column has to be filled up. That is contrary to the rules, my lord. When the secretary forwards, as per the type plan maybe, he can only fill up number 4, number 5, number 6, number 7 and number 8. Rest have to be nominated members. They have to be persons that the government nominates without reference to any suggestion or proposal by anyone, my lord.
Mostly in this case, we are not on the merit. If I go on the merit, then I can say they are locus standi only. They have already lost the case.
That letter was shown by whom?
This
by...
one.
We are not on the merits, my lord.
This one. It is
the
director to decide, Lord, so independently.
The school can't go to managing committee for 1 year also. Whoever a sponsoring body might be. But that's the thing. Yes.
55.
We'll pass orders in 30 only.
Obliged.
Yes, Mr. Paske. Where's the...
This matter will be leading by Mr. Savage.
This is how you practice in Tura?
No.
In Guwahati? No.
Guwahati.
Your Lordship, Mr. Shula is on legs.
But here MS Kolni is shown.
Your Lordship, she is led by Mr. Shula.
What's the matter about?
My lord, here this is a, no, this is a contract. Contract by construction of bridge allotted by the PWD department, government of Meghalaya.
How long are you going to take? 5 minutes.
It may be a simple case, it will be hardly 10 minutes activity completed.
Yes.
Yeah.
Start.
My lord, here actually the petitioner was allotted a incompleted bridge. Someone else.
An incompleted bridge.
Incompleted bridge. That was some contractor was allotted, but he could not complete the bridge. Half done condition.
Oh, you mean to complete the work of an incomplete bridge?
So on the
work, an incomplete bridge.
But bridge that was not completed by the earlier tender, because to whom that was issued.
Okay.
So subsequently on war footing, the department requested me to complete the bridge as early as possible. So accordingly, I was given a work order, page number starts at 10, starts from 10 in the petition, Annexure 1.
Yes, annexure 1. Yes, what do you have to show?
Yes.
Bagmara. This is where
Bagmara.
Where exactly is located?
That is located is that South Carolina.
I know South Carolina. Where exactly in Bagmara?
So accordingly, I completed the bridge.
Yes.
I completed the bridge and submitted by all bills, my bills.
No, but Mr. Sahu, but
Yes.
this was by a proper item rate contract, correct? Which you entered into the contract. You sign a formal contract, correct?
Yes,
Where
yes.
is that?
I signed the formal contract. Page starts 16. No, 16.
Page 11, the memorandum.
Memorandum.
Now I want to see the amounts. Okay, fine. How much was completed?
Amount was 4,87,000. 30,000. 4,87,000. 4 crore 87 30,500.
So that was the tender amount.
Yes.
4 crore 87.
So out of that,
Second. 4.87 CR. Okay. Yes.
Out of that, I completed the bridge at the cost that was bill has been submitted. That comes to 4 crore 8 lakhs 30,688.
Where you get that from?
In the bills and submitted my bills.
Less than the tender amount.
Yes.
Uh, 4.7 is tender amount
Yeah.
as has been submitted. Now, okay, before we get to that, there's only one thing. Now, this amount which you claim by you're seeking to get the balance of my writ petition, is it a certified admitted amount?
Yes, sir, there is no dispute on that. There is no dispute on that. Actually, the problem is here in this case that the department's internal arrangement, PWD person, they have not sent their bills, which I have submitted after approval to the Central Ministry of Transport and Highway Authorities. That's why that was pending in between.
Okay.
During that, I have been facing those consequences. That is the only problem here. There is no dispute, nothing.
What is the balance amount which you are due to you?
4 crore 8 lakhs.
No, 4.87 crores is a tender amount.
Out of that, 4 crore 8 lakhs, I have filed the bill.
No, how much has been paid to you?
Part payment is fine. Some payment has been.
That's been your fingertips. How much the tender amount? Your work you finish. That's the amount you spend. How much you've been paid? What's the balance amount which you see they have to pay?
I'm explaining right.
The tender amount 4.87. That means that the amount is already sanctioned.
And subsequently, that has been enhanced also. Subsequently enhanced by the department. That comes to 7 crores something. 7 crores in the first. Initially, it was 6 crore 61. Subsequent, that was 7 crore 51 lakhs, like that. So out of that, they have completed whatever portion they have completed. That has been verified and supervised by the department. There is no objection, no dispute on that. But the PWD officers, they have not submitted that bill after approval. That's why that is pending. Is not finance has not been issued the release the funds.
So what is the amount pending? That's what you could want to know.
Pending amount is 4 crore 8 lakh 30,688.
Okay. In the prayer. So
Page 54, that has been referred as 54 of the petition, writ petition.
Very good. 54.
54.
You mean to say that the revised cost estimate was submitted by the department and that amount not been sanctioned till now?
No, that is petty.
Then it will be a tough order.
That is the main problem with me. And they are not, the reason behind it I cannot say that they are well known for
Because
that.
you understand now the initial tender amount was 4.87 crores. Then the revised cost estimate became to 7.25 crores. So you have completed work for 3 crores. You got the bills only for 3 crores something, that means. So 4.08 crores still outstanding. Now where is that paper trail regarding the revised cost estimate been sent?
Everything is that is the PWD, Chief Executive of PWD, Meghalaya.
No, from the annexures, where they show that is the department has, acknowledged that they have to pay this amount. No, where the department acknowledgement by the department that they are not undisputed bills.
That has been reflected Annexure P in the rejoinder affidavit P8.
P8.
Filed by respondent number 4.
Page number?
P8. (46).
Page, what page?
46.
Rejoinder to the affidavit is one number 4.
4.
At page 46 is nothing.
Page 46 P8. I am reading this Annexure P8. Revised estimate for construction of bridge number 166.5.
P8 is not page 46. P8 it's kindly help the court here.
Sir,
I
this
can't
is the rejoinder affidavit filed on behalf of the petitioner to the
see that
respondent
one.
number 4.
Exactly, this one for just see.
It appears that they have two rejoinder affidavit, Your Lordship.
This copy, I think, 46. The region number is 4. Something, I think, some paging mistake. This crops up.
What happened, Mr. Paske?
pagination mistake.
Then you correct it.
Page mistake, that's the problem.
You fix it. You please correct it. I don't want to keep CAV for nothing. You correct just, you collate the pages together, court copy and your copy. We'll have it tomorrow.
Not tomorrow, Your Lordship, please.
Tomorrow there is I was some personal
Festival?
personal difficulty.
You please collate the pages. This will help the court. Otherwise, especially when we have to write judgments, very difficult.
Yes, very difficult.
You refer to Annexure P8 and we sometimes don't. I won't find it also in the. We understand the case is cut. Is only thing to see whether the bills are certified and.
Lordship, its amount, there's
no dispute.
The work is 4 crores, already 3 crore plus has already been paid, Your Lordship. It is not a case that admitted amount, Your Lordship.
No, what about the revised cost estimate then of 7.5?
That has not been approved, Your Lordship. There is no clause. So you remain asked.
Then anyway, just when you can do next week?
2 weeks.
Okay, Mr. Paske, assisting Mr. Sahu, prays that he may be allowed some to correct the pagination.
That's why they filed a writ petition.
And collate the same, yes. And Manish, when was the contract finished?
In 2013.
Lordship,
But there has been
it's barred by
communication
law
to
of
and fro.
limitation. Why they filed a writ
There's
petition,
been
Your
lots of
Lordship? They cannot go for a civil remedy, Your Lordship.
Communications without
Overcome the
any
limitation.
They cannot go
To
for a
beat
civil
the
remedy, Your
statutory
Lordship.
limitation. Yes. Why not? They have to
Limitation
try.
will not be in effect
That is
because we have been communicating with the state government.
Yes.
Apply, Your Lordship.
56,
That is connected, Your Lordship. 56 is connected.
7,
57. 57 you asked him. Yes, correct. Yes, correct.
seven,
57, my lord, relates to notional promotion. He's since retired, my lord.
Notional promotion?
Notional promotion, my lord. My lord, this matter, if your lordships can have it on some other day.
Well, you prepare me for that, Manaksha.
No, my lord, I had a hearing in before the division bench also. So this,
I went there also, Your Lordship. And I have
Division
to
bench
reply
sitting now?
tomorrow. Lordship,
Yet to sit.
yes.
my lord, second TV.
Second TV.
Yes, on the premise the nobody will person difficulty. This
After
matter
2 weeks,
after
Lord.
2 weeks. Notional promotion. Now, when did he retire?
My lord, 2023, my lord.
58,
Lord, if this matter can be listed tomorrow, my lord.
Not tomorrow. Not tomorrow.
What the matter is about?
My lord, this is where this petitioners, my lord, they are in the business of exporting limestone, boulder stone to Bangladesh, my lord. So now because of one association, my lord, involved in this entire thing, my lord, they are not able to.
Where's MS Punjab?
Punjab, my lord, says in Guwahati today.
Then the thing is that he said that whether the petitioner interested in pursuing the matter at all.
My lord.
Interested?
My lord.
Otherwise, you see, we're not going to just have the matter at your insistence because every time the matter was up, where's the prayer? Is it still survives consideration?
There is a case of streamlining, right? It is case of streamlining.
It survives. What is your grievance?
My lord, here.
Oh, this private body is relating.
Yes,
the
my lord.
trucks.
Yes.
Okay, you're exporting boulders now?
My lord,
The market
it
gone
is,
now
there
because
is monopoly, my lord. Only one group of people, my lord, they are allowed.
Mr. Majal is monopolizing it.
Yes, my lord. That is the truth, my lord. Because they have the monopoly in the entire export, my lord.
Entire Rivar Mingi.
Yes.
They are mostly they are agreed by the streamlining, Your
It is
Lordship,
not
by
true,
the
my lord.
additional deputy commissioner.
Even the order, my lord, passed by the
For the smooth
passed
running
by the SDO, my lord.
flow of traffic, Your Lordship.
It refers to only one organization. Yes, they have been given the.
They want.
It is not
Lordship,
true, my lord. It is because the one organization, even from the administration side also, they are authorized, my lord, to regulate the entire business. Yes, but by the authority, my lord. It is there reflected in the order. It is there reflected in the order, my lord.
It is a case.
And
we
moreover, my lord,
streamline,
what
Your
is
Lordship.
happening is, my lord, they are made to park their vehicle in a private parking lots, my lord. There are 4 private parking lot that has been set up.
Owned
There-
by them.
My lord, mostly controlled by the private individual, my lord. And 150 rupees has to be paid by each truck owners, my lord. Truck
So
drivers.
if you don't park there, where would you park?
They will not allow, my lord. It has to
You mean
enter.
that they're operating a mafia there?
Yes, my lord. My lord, may kindly imagine 4 parking lot, 500 vehicle each parking lot, my lord, 150 rupees each day for parking, my lord. How much money, my lord? In a day, my lord, around 20 lakhs, my
Now,
lord.
your petitioner, how many trucks does he operate?
My lord, only few of the petitioners, my lord, they have come here before this court,
How
my
many
lord.
trucks operate?
My lord, 1, 2, my lord, no, and mostly they are not in a week, my lord. They are sometimes getting only one time, my lord, one trip. Whereas,
They're not allowing
my
more
lord,
trips.
and moreover, the system that has been created, their organizations is issuing tokens, my lord. If we do not have this token, we cannot export the item.
Why don't you join the organization then?
They have their own group, my lord.
I was saying that you can't beat them, join them. Okay, after 1 week, yes.
Apply, Your Lordship.
This happens everywhere, I think.
62.
Apply.
Who's arguing counsel? Secretary, but yes.
Lord, I've prepared 2 charts, my lord, for the convenience of your lordships. One list of dates and one.
Same matter, it was like the earlier matter, not least of final bills.
Yes, my lord. But the first is the list of dates.
Yes.
So the final bill, my lord, was submitted on 20th of November 2023, and the amount is 1,97,64,980. Now, out of this, my lord, 62,32,798 has been paid to the petitioner. Now, the remaining amount, my lord, the petitioner was compelled to file this writ petition, my lord. Now, writ petition was filed on 30th of April 2024. And my lord, the claim in the writ petition is the pending dues of an amount of.
Now you mean to say, do you know the penalty of the writ petition? 60
Yes,
lakh was paid.
60 lakhs was paid. So, my lord, if you have the second table which I have prepared,
Yes.
so my lord, as per us, the pending
How
is.
do you say this amount paid in 26/9/2025 when we're still in?
Oh, sorry, my lord. Sorry, this will be 24, my lord.
You know how this court's concerned about dates. You know,
Yes, my lord. I apologize, my lord.
Be very careful. It's 24.
Yes, my lord. So my lord, as per us, my lord, the due is 74 lakhs 35,580. As per the government, it is only 49,69. So my lord, there's a 28 that is disputed. So my lord, all we are praying for is release this 49, and the disputed we will.
We'll file a civil suit.
Yes, my lord, we'll take recourse to law, my lord.
Where's your admission of 49 lakhs in your affidavit?
Yes.
In the affidavit of the state.
Affidavit for the state.
Where's that?
Para 8, my lord. So our claim is 1 crore 97 lakhs. At para 8, they're saying 1 crore 72 lakhs. my lord.
No, my lord. Here, my lord, what it says. In response to the averments made in para 13 and 14 of the writ petition, the answering deponent states that from reading of letter dated so and so, my lord, which is annexure 9, page 22 of the writ petition, it can be seen that the ongoing tender value was rupees this, which was subsequently enhanced. This is what the letter is showing, my lord. Subsequently enhanced to rupees 172.375 lakhs. In other words, there was an enhancement of 8 lakhs something, my lord, only from the original tender value. The said enhanced amount is inclusive of construction of the subway. My lord, this is what the letter says. The claims of the petitioner regarding numerous items of work amounting to rupees 30 to 35 lakhs, which is not included in BOQ, and deviation statement cannot be accepted, as no such work was carried out at site apart from the construction of the subway. Additionally, any items not listed in the BOQ or
But I'm
deviation
saying-
statement which falls outside the scope of the tender agreement cannot be considered.
No quarrel with that. They have no
Yes,
quarrel with that.
yes.
So where's the amount we said that they are due? They are liable to get another.
This 172 which they are saying, my lord. 163 at para 8
But that
is
only
the
referring to a
amount.
letter, my lord. Now, whether there is a in my respectful submission, it is not an admission.
Where's the thing where you have you brought it on
the
the
rejoinder,
court regarding payment of that 60 lakhs
Yes,
on
my lord.
26/9/24?
My rejoinder, my lord.
Okay. That letter will be important. Page?
Page 10, my lord, is the payment I have received on 26/9/24. Because the allegation made by the state respondent is that we are not coming forward for inspection.
Lord, because the
just let me.
Yes.
Now, if you are not coming forward for inspection, my lord, they won't have released this amount. So the delay is on their part, my lord. Now, if your lordships has page 11, is the envelope, my lord, which, my lord, they have my lord, forwarded two letters on top of the envelope, 29th February 2024 and 3rd of April 2024. So in the affidavit, they say that they have sent these two letters to us. However, we have not come forward. Now, if your lordships kindly have the envelope and the seal on the right side, my lord. I'll show your lordship the original of that, my lord. Where is it? I'll just show your lordships the original envelope. Just look for it. Your lordships kindly have page 13. This is a little visible. So these letters of February and April actually, you know, delivered to us in June, my lord. Page 14 is the.
What is this letter? Your next is letter.
They have an X saying that we have called them for inspection, but we have not gone for inspection.
No, how did she receive in June?
I'll just show your lordships. If your lordships,
13.
yes, your lordships. If
I'll do forensics now.
no, I'll just show the original. What I'm trying to say is, my lord, they're trying to attribute the delay upon me. They themselves send backdated letters, my lord, in June, and then they file this affidavit, my lord. And after they file this affidavit, my lord, they release payment to me. That means I don't require to go for inspection because everything is clear, my lord. If I was not cooperating, my lord, why will they release the 60 lakhs?
Okay. They're saying that you didn't come to an inspection, but
Yes.
notwithstanding that, we're giving 60 lakhs.
Yes, my lord.
So
No. They are saying in the affidavit that we cannot release the remaining amount because you are not coming forward. They enclose two letters, my lord. Now, those two letters, by page 11, what I'm trying to show is those two letters, which is dated February and April, it's actually sent to us in June, my lord, after the writ petition has been filed.
What are those letters? Let's see which are those letters.
Yes, wait.
that is not acceptable.
So let's see.
My lord, the affidavit filed by the state, my lord, at page 21 and 22.
Yes.
So, my lord, their statement,
So this is page 20.
page 21 and 22 are the letters, my lord.
Okay.
And they have made their submissions at para 13.
That's okay. It's okay. So. Then next letter is 3rd April.
Yes, my lord. Now, if your lordships kindly.
Date you're not intimate the report and the sign about your joint inspection at site. For exchange of terms with you. Okay.
Now, my lord, if your lordships kindly have page 8 of the affidavit, the averment made by the state, my lord.
Yes.
It starts with further, my lord.
Yes.
Further, the answering deponent states that a running bill as well as the final bills of the work has been prepared by the department as per usual practice, incorporating all the executed items of work based on the BOQ and the approved deviation statement. And for the settlement of the final bill, the Office of the Executive Engineer had instructed the contractor representatives to inform the contractor petitioner to go for a joint inspection for the site verification, since the final bill submitted by the petitioner has to be scrutinized and necessary paperwork has to be carried out after verification of the site before clearing the said bill. The department had issued letters dated 29th of February and 3rd of April.
Mm.
Now, if your lordships has the list of dates, again, the writ was filed on 30th of April, my lord.
Yes.
30th of April. So what I'm, my lord,
The writ was filed after these letters were issued.
yes, my lord. After these letters were issued.
You never received them.
No, my lord. Now kindly see the original envelope, my lord. They were, my lord, sent to us in June, my lord, after the writ is filed. And then after they filed the affidavit, now the affidavit also was filed on.
Dispatch on when? You can't make out this dispatch.
Yes, there's that.
Dispatch on front.
My lord, that seal, the date. It says 11th of June, 2024. Letter numbers mentioned on top, my lord. 2 letters together in the same envelope.
Can't make out. Anyway. You received
So, my lord.
Received on 11th of June only.
Yes, my lord.
Same day.
Yes, my lord. The letters and the letter numbers mentioned on top.
No, same day they sent it, same day you got it.
Same envelope. 1 letter of February and 1 letter of April sent in the same envelope. And they're saying that we are not coming for inspection. Notwithstanding the envelope, after this affidavit has been filed, they have released 60,000.
The letter only said that, see, that it's the 3rd April. I have the honor to inform you that till date you have not intimated the report and the sign about joint inspection at the site. Moreover, your extension of time has not been received for finalization. However, your bill has been forwarded for further action. So what they have done, that means on their own they finalized the bill.
Yes.
And sent it.
So, my lord, what I'm trying to say is these are just allegations, my lord. A letter which is backdated, sent, my lord, in April after. So, my lord, now the only amount as per them is 49. So they release that, and the remaining whatever.
Is, you admit 172 is a contractual amount, correct?
My lord, what we have stated, my lord.
No. You know, one thing, just one simple yes or no, Mr. Bhattacharya. 172 is a contractual amount, correct? Yes or no?
My lord, here
So
my
yes or no?
my respectful submission, my lord, we have only.
No,
my
is
lord,
it yes or no? 1.72 is a contractual amount.
my lord, then
correct.
if that is so, my lord, kindly allow me to take instructions whether that will be admitted
172
or
is a
not.
contractual amount, and you've given certificate of completion, correct?
Yes.
Then,
My
so
lord,
that's a limited amount, and if you've released another 60 lakhs, that means whatever 49 they're due for that, whatever excess work they've done, that'll subject, they can go and file civil suit.
Kindly allow me some time to take instructions in that regard, my lord. Because here, my lord, what we have stated is that the para clearly says that what is written in the letter, my lord. But
No, leaving that aside,
in fact, there
Mr.
is no
Bhattacharya,
clear
leaving
admission
that
as
aside.
such. My lord.
The only thing is that whether contractual amount is 172, he's been paid some whatever, he's 49 lakhs outstanding. That's all, as per contractual amount.
So, my lord, allow, if that is so, my lord, kindly allow me to take instructions whether that is there admitted.
I wouldn't try regarding the in the course of hearing Mr. K. Bhattacharya, please wait out to obtain further instructions on a contractual value and amount advanced to the contractor.
One page, my lord, of the writ petition. Page 55 and extra 9 of the writ petition, my lord. This is their letter, my lord.
Page 59.
Page 55 and extra 9.
Yes.
In the middle of the page, my lord, as per enhanced tender value, 170.
This is fine.
My lord, because otherwise we have denied most of our claims.
No, denial is fine, but I mean, the thing is that when even suppose as a young lawyer, what were you taught to write to? You know what were you taught when you file a statement?
My lord,
when you file, what were you taught? Is that it starts from denial? That's all. Whether it might be is gospel truth, so
No, my
we
lord,
start with denial.
whatever
so
is
denial
fact.
is
My lord,
fine.
in para
But
10,
denial is substantiated by.
no, my lord, even in para 10, my lord,
Yes,
we
yes,
have
after
clearly
1 week.
stated bill number four stages
You
of bill.
get
My lord.
instructions. How much is the contractual amount?
My lord.
How much you've advanced to them?
My lord.
And as per the contractual amount, how much is pending? That's all. That's the admitted amount then. And if you already given them a certificate of completion, that's it.
So, my
And the
lord,
work's been handed over
I'll
to
take
you.
instruction.
Excess work, I mean, that is the contract
We'll
was
claim,
right.
we'll claim in the proper forum, my lord.
Yes.
Obliged.